May I please? I beg to mention item number 33, Lordship. The other side also present. Lordship. In this matter, Lordship, need some time, Lordship. It will come after due vacation, Lordship. In this matter, earlier, Dr. VMS sir conducted, Lordship. Need some other senior.
What do you want after Bihu?
After due.
Acha. Mr. A.U. Ahmed, Lanak counsel for the petitioner, 6 adjournment in this case with a request to post the matter again after Bihu vacation on the ground that the arguing counsel is unwell. Mr. S.K. Medhi, Lanak CGC is present and does not have any objection to the prayer is allowed. In view of the above, admission hearing of this matter stands adjourned for 4 weeks.
Lordship, item 53,
Yes.
I had to file an impleadment petition, but the respondents have again retired. So he will give me the names and then.
On the request of Mr. D. Dekal, Lanak counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable him to file impleadment petition. So as to bringing on record the new incumbent, Lordship, responsible for implementation of the court's order. List accordingly.
I'm obliged, Lordship.
May I please, your Lordship? My Lord, I beg to mention an urgent interlocutory application, my Lord. I have been punished from enforcement inspector to, my Lord, head assistant. Now my salary from last 7 months has not been paid also, my Lord. For that an IA has been filed, my Lord, in a pending.
7 months salary not
My
paid.
Lord, my Lord.
When do you want it?
My Lord, on any date as per convenience, my Lord, on coming Friday or next Tuesday, my Lord.
Next Wednesday.
Obliged. May I please, your Lordship, my Lord? In a pending matter, my Lord. Promotion was granted later on, my Lord, by the department pursuant to the interim order, my Lord. And I'm going to retire on 31st, my Lord. Only some part of it remain. Only the salary is not paid. Some part of it, my Lord. Now this month it will take on loss in only 2 minutes, my Lord.
It cannot be done before Bihu vacation.
My Lord, 31st is going to retire.
So what? It's only the money is what is to be paid.
No, my Lord. Yes, my Lord.
After 31st, no
and
money.
is, my Lord, the regular award.
Tell me one thing. If you retire, then the money cannot be paid to your client.
Surely, my Lord.
Then why are you unnecessarily making?
My Lord, one thing, my Lord, the regular he is temporarily promoted because the case is pending. Not finally, just what regular award is not till not used, my Lord. That's only one. It will take 2 minutes on your Lordship. Other side did not contest, my Lord. Only.
You will have it on 28th of March. 28.
May I please, your Lordship? One contempt matter that was listed for yesterday. Her side, we missed. Mr. Lordship was kind enough to fix after 3 weeks. It is really linked to pension because pension were not forwarded. They say, may I pray for Friday or Monday, my Lord?
Not possible. Once the order is passed, it cannot be changed. It is a judicial order.
Now,
Mr. Boro, I'll tell you one thing. You are entitled to, but you all only think about your interest. Somebody will put it up, they see what the judge is doing. He is passing judicial order after 3 weeks and getting the matter after 2 days. We also have certain things to.
then
so,
I have to file.
No, you have to file an IA. You have to file it. Can't help it.
Because
Because the things are bloated. You don't know what you don't know. You have no idea what we have to face.
Yes, my Lord. That's why.
So you are only concerned about your client.
Yes, that's correct, my Lord. That is correct.
But we have to follow our discipline.
Very sorry, my Lord. Because
Cannot
I file I.
You file it, I will consider.
My Lord.
Yes.
Obliged.
May it please, your Lordship. Lordship, I beg to mention item number 34 from today's list, my Lord. This matter has become infructuous, my Lord.
Why it has become infructuous?
My Lord, the authorities recalled the suspension order, my Lord. He is
Right.
reinstated, my Lord.
Mr. M. Sharma,
Yes,
as by the Lanak counsel for the petitioner submits that the suspension order under challenge in this case has already been withdrawn and therefore the writ petition has become infructuous. Mr. R.R. Gogoi, Lanak standing counsel for
Sorry, I'm not there.
You're not there?
Not there.
Okay. Taking note of the submission of Mr. Upadhyay, the writ petition stands closed.
Deeply obliged, my Lord.
Yes, yes.
Lordship, beg to mention item 31, your Lordship. Item number 31. In this matter, the matter has become infructuous, your Lordship. Because notification which they have challenged, the department has recalled that notification, Lordship.
Who is
Yes,
for the petitioner?
I'm for the petitioner, my Lord.
So we'll close it. Mr. A. Tiwari, Lanak counsel for the petitioner, and Mr. R.R. Gogoi, Lanak standing counsel Forest Department, Assam, have submitted in tandem that the government notification under challenge in this writ petition has already been withdrawn and therefore the matter has become infructuous. So stop taking note of such submission made at the bar, the writ petition stands closed.
Deeply obliged.
May I please, Lordship? I beg to mention item number 28 from the daily list.
Item number
28. And for the
Yes,
petitioner, I have taken consent from the other side, Lordship.
yes.
So today, my lord, my senior some difficulty, Lordship. I pay for password for the day.
On the prayer of Mr. D. Gogoi, learned counsel for the petitioner made with the consent of the other side, this matter stands passed over for the day.
Highly August.
And please, your lordship, I beg to mention item number 3, my lord. Matter may be adjourned for the day and matter may be
Item 3,
yes, my lord.
as paid for by petitioner's counsel, the matter stands passed over for the day. Yes. Yes.
May I please, lordship, item lordship 45, lordship.
Yes. 45, what do you want?
Lordship pray for some time, lordship, they have filed the affidavit, reply the affidavit, so some
You are for whom?
petitioner, lordship.
The learned counsel for the petitioner prays for and is granted 3 weeks time to file rejoinder
After
in
2 weeks,
response to the
lordship,
counter affidavit filed by the respondents. Yes, list accordingly.
May I please, your lordship, with the consent of other side, I beg to mention item number 26 and 27, lordship. Kindly matter may pass about for the day, lordship.
26 and 27.
Yes,
You
lordship.
are for whom?
And for the petitioner.
All right. On the request of learned counsel for the writ petitioner made with the consent of the other side, admission hearing of these matters then adjourned for 3 weeks. List accordingly.
May I please, your lordship?
Yes.
My lord, I have been instructed to withdraw the writ petition as the matter has become infructuous, my lord, because the respondents have finally proceeded with the selection for promotion to the post of director. So, and they have already published the minutes.
All right, you take down. Mr. A. Sharma, learned counsel for the writ petitioner submits that the respondents have concluded the selection process and the order of appointments have already been issued. As
No,
such,
order of appointment, no, only the selection committee has met and the minutes have been
Director, which post?
to
Director,
the post of director, Directorate of Geology and Mining.
the selection process has already been concluded. Therefore, the writ petition has become infructuous. Who is appearing?
I
Mr.
appear for 1 and 2.
Mr. D. Boral and G. Assam is present for the respondent numbers 1 and 2.
Number 4.
And Mr. S. Datta, learned.
That's what number 4.
Yeah,
Private respondent.
private. S. Datta, learned counsel for the private respondent number 4. In view of the submission made by Mr. Sharma, this writ petition stands disposed of as not pressed. Is there any interim order? No.
No, my.
What about the IA? Is it still pending?
No, IA was for impleading the respondent number 4.
Okay.
Highly obliged.
May I please, your lordship? I may be allowed to withdraw the petition, lordship, because lordship matter has become already in practice, lordship.
Mr. H.K. Das, learned
NK
counsel,
Sharma.
NK
Sharma.
Sharma, learned counsel appearing in the petitioner submits that the writ petition has become infructuous, therefore the same be closed. Mr. D. Boral, learned G. Assam and Mr. S.P. Das, learned counsel for the
2, 3 and 4, my lord.
G. Assam for 1 and S.P. Das, learned counsel for the respondent numbers 2, 3 and 4 are present. In view of the submission made by the petitioner's counsel, writ petition stands disposed of as infructuous.
Deeply obliged.
May I please, your lordship? This is a contempt proceeding against the judgment and order annexure F. Your lordship,
Mr. M. Talukdar, learned counsel for the petitioner.
annexure F.
Alleging willful disobedience of the directions contained in the judgment and order dated 25/7/2024, passed by this court in WPC number
Case 40,
7880/2022. This contempt case has been filed. I peruse the statements in the contempt in the petition. If you notice, returnable. Having regard to the nature of direction issued by the court and the alleged violation, this court is inclined to issue notice only upon the respondent numbers 3 to 5 at this stage. As such, issue notice returnable in 8 weeks. Petitioner takes steps for service of notice upon respondent numbers 3 to 5 within a week from today. The question of issuance of notice to the respondent number 1 and 2 will be considered at an appropriate stage.
They're supposed to get instruction.
Lordship, in this matter, they have to meet Assam Rifle a party because their document verification was done by the Assam Rifle. So they are not the parties here, Lordship,
In all the cases.
all the cases.
I may be allowed to then implement them.
Why did you not make Assam Rifle Party?
That's it, but my, actually, I have submitted the representation before the NER lordships.
Hmm.
Because as per their guidelines, if somebody is aggrieved, they should file representation before the NER lordship. That's one number 3.
That is true, but these are technical plea, they will take it. It is
I may be
available.
allowed to implement them. Lordship.
But you see, there is one problem. You think about it. Ultimately, these matters go into a crunch situation at some stage. You are impleading, and if the pleadings are not there, then it will not be of any use to you. With the, what is the, Mr. Roy?
Document verification was done by the Assam Rifles, Lordship.
Yes.
So whatever they have done, they have prepared the list. So
So your entire case's complexion will change.
Our grievance is that although we have scored more marks than the cut-off marks, lordship, in spite of that, we have not
No,
been
no.
selected.
by the year.
But
All right,
otherwise, lordship,
yes.
after qualifying all those document verification, the result is declared.
Okay, Mr. Deka, you see, you have 3 options. You choose whichever option you want. There is no difficulty. These respondents, they are saying we have nothing to do. So your sole respondent and main respondent is Assam Rifles. So you have to implead Assam Rifles. Now, merely by impleading, whether your purpose will be served or do you need to make some averments in the writ petition, some allegations. This is what you have to consider. So option is either just implead and do nothing. Then Assam Rifles sometime will come and they will say that there is no such pleadings, no such averments. Other option is to amend the writ petition. That will take a long time.
Amendment.
And the third option is to withdraw and file afresh. Whichever you want to choose, your decision. The court doesn't have anything to say, but we will have to go by the legal
Yes.
principles. So do you want to think for a little while? We can give you 15-20
Lot.
minutes time and you come back. But whatever you want to do, we will allow you now. But think about what is the situation which is going to unfold. Because this will be contested. They don't want your clients to be appointed. You will want an appointment. Then the pleadings will be there. The court will go into the nitty-gritties and then have to give a finding. And these are in any case difficult matters because they will say we have concluded, these things are over.
After some time.
How much time you want? Half an hour?
Yes, Lord.
You come after half an hour. Think about it. Think
Sure.
about it. But whatever you want today, we'll give you.
Lord.
Yes.
May I please your lordship? I have been reinstated. My lord.
You have been reinstated.
Yes.
So the petition has become infructuous? Yes. Mr. S.B. Lashkar and counsel for the petitioner submits that during the pendency of this petition, his client has been reinstated. Therefore, no live cause of action survives in this writ petition. Taking note of the submission of Mr. Lashkar, upper line, Mr. D. Gogoi, learned SC Forest Department is present on behalf of the respondent. Taking note of the submission of Mr. Lashkar and granting the petitioner liberty to agitate any other grievance associated with his suspension at a later date, if and as and when the occasion arises, this writ petition stands closed. You're given the liberty.
Yes, ma'am.
Yes.
Both.
Achha, 2 petitions are same.
Yes, my lord.
Same suspension, both.
Same resolution.
Achha, then same order do that.
Chief, I'm appealing for respondent numbers 5 and 6.
Achha, Ms. U. Sharma and G. Assam is present on behalf of respondent numbers 5 and 6. All right.
May it please your lordship, I appear for the respondent 2 and 3, NIPCO in this case. On the last occasion, instructions had been sought because of whether the.
Hey, 31st March is nearby.
Yes,
Allow
please.
him.
I have
be.
instructions, we are agreeable to him remaining in station till 31st.
My lord, my humble prayer is that where I am posted, there is no school for 11 and 12.
That you have to make arrangements. We can't help it. We are not service providers. You had a grievance, your daughter was in mid-academic session.
Yes.
We
we
wanted-
did,
That you have to make arrangements. All of us have to do it.
Like,
Everybody, even when judges are transferred, they have
Yes.
to make alternative
Yes.
arrangements. Nothing can be done about it.
my lord, then representation or something may be considered for the that point.
All right, we'll pass an order that he will not be disturbed till 31st. Insofar as his other grievances are concerned, it will be open for him to submit representation. If and when it is done, you look into it objectively. Will not make any comment. Mr. Ahmed, you have to tell your client that
Yes.
he is in a transferable job.
Yeah.
So every place of posting cannot be suitable as
Is-
per his palate.
Actually, he has served more than 14 years in very remote area.
Can't help it.
Whereas his replacement has already joined in the project, so for that reason.
All right, I
Right.
heard Mr. Ahmed, like counsel for the writ petitioner. Miss R. Devi, Lanark Council is appeared for response number 1. Full stop. In terms of the order dated 7/3/2025 passed by this court, Mr.
Atreya.
A.
Atreya.
Atria, Lanark Council has appeared today on behalf of the NIPCO authorities. Full stop. The core issue involved in this writ petition is pertaining to the grievance of the petitioner arising out of the transfer order dated 21/2/2025, by means of which the petitioner, who is presently presently posted in the Assam Gas-Based Power Station, NIPCO Limited at Bokuloni, Dibrugarh, was transferred to Doyang Hydroelectric Power Station in Nagaland. Full stop. Taking note of the nature of grievance expressed by the petitioner, this court had fixed the matter today so as to enable the NIPCO authorities to respond to the primary grievance of the petitioner that since his daughter is in mid-academic session, he should not be disturbed from his present place of posting till 31/3/2025. First up, Mr. Atreya submits on instruction that the NIPCO authorities are willing to have agreed to allow him to continue in the present place of posting till 31/3/2025. If that be so, one of the grievances of the petitioner automatically stands resolved. Insofar as his larger prayer for altogether cancellation stroke modification of the transfer order is concerned, this court is not inclined to make any observation in that regard. Full stop. Inconvenience of a departmental inconvenience of an employee of the department may be a good ground for the authorities to look into the matter, but the same cannot be a justifiable ground for the court to interfere with the transfer order. Therefore, granting liberty to the petitioner to submit a fresh representation, ventilating his above grievance before the authorities, this writ petition stands closed. If such a representation is submitted, it will be open for the authorities to look into it objectively and pass any order that may be deemed fit and proper in the facts and circumstances of the case. Writ petition stands dismissed.
Okay.
You must tell your client that
Yeah.
beyond that transfer matters, the court
Yes,
cannot.
I know.
May it please your lordship. Lordship, this is a writ petition for appointment of constables GD in general, Central Armed Police Forces, your lordship.
Yeah, you see, the reason why we'll dismiss it today is that this is a 2018.
Yes, lordship.
You have come after so many years. What is your instruction?
Instead, vacancy not there, lordship, and similar matters or all petitions are dismissed by this court on delay and laches ground, lordship. Similar matter.
Okay. All right, your name, please?
A.K. Kanu, my lord.
Eke?
Kanu.
Had Mr. Eke Kanu, learned counsel for the petitioner, also had Ms. S. Barua, learned CGC appearing for the respondents, full stop. The petitioner's case, in a nutshell, is that pursuant to the advertisement notice dated 21/7/2018, he had participated in the recruitment process for appointment of constables bracket GD bracket close in the Central Armed Police Forces bracket CAPF small s bracket close NIA and NIA comma SSF and riflemen bracket GD in Assam Rifles constituting around 54,953 numbers of vacancies. Full stop. The grievance of the petitioner is that although he had scored higher marks, the petitioner belongs to the OBC category. Stop. The grievance of the petitioner is that although he had scored higher marks, then the unreserved category candidates, yet he has not been appointed. Full stop. Hence this writ petition. Stop. Resisting the prayer made in the writ petition, Ms. Borua has submitted that the selection process, but Ms. Borua submits that there is no merit in the plea raised in the writ petition. Stop. Moreover, the selection process pertains to the year 2018, and on conclusion of the process, all vacancies have been filled up. The learned CGC has also invited the attention of this court to the judgment and order dated 23/10/2024 passed by this court in WPC number 4425 of 2024, whereby a similar writ petition was dismissed. On the ground of delay and laches. I have perused the same. After going through the materials on record and keeping in mind the requirement to maintain uniformity in judicial orders, this court is of the opinion that the present writ petition is also liable to be dismissed on the ground of delay, as there is no plausible explanation for the delay in the writ petition. Consequently, the writ petition stands dismissed.
May it please your lordship. My lord, the petitioner was working as a junior assistant in the office of senior sub-registrar Kamrup. When he was suspended on being arrested, then the disciplinary proceeding was there and he was dismissed from service. He filed an appeal, my lord. During that time, a document which was not with him was not been able to submit. Thereafter, he filed an application for submission of the document, and just he prayed for that to be taken as a part of appeal. That much. The appeal is pending, but they have refused to take it as a part of appeal. So that before your lordship. Because the charge was this, my lord, that some documents, some books, some registers of the office was found in my residence. Because during the time of transshipment from.
Mr. Rajchodri, tell us one thing. You want that the appeal should be heard.
Appeal should be heard, and but only this document should be a part of the appeal.
Already an order, lordship, the appeal should be heard. That is the order.
There was an order when the appeal was filed. There was an order from this court. The appeal should be heard and disposed of as per Rule 24 of the Disciplinary Appeal Rules. But subsequently, during the
what is the date of that order?
The order is that page. I have annexed my lord page.
Page
13/11/24. 13/11/24, page 24.
Appeal should be disposed of within how much time?
As per Rule 24, within 3 months.
So the 3 months is over now.
That hearing is going on. Malad, he was last time on 4th Malad, he was appeared, lordship.
I have appeared, my lord. My only consideration is that the subsequent
You
document.
file an application in the document. If they don't consider,
They have not considered. That is
will
why.
you take up that plea if the appeal goes against you?
But
If that document is material,
is
and they
material
don't consider, the appellate order will be set aside on that ground.
that much observation, my lord, if your lordship gives.
Nothing. We can just tell them to conclude the hearing of the appeal.
My lord, we have filed that.
But Mr. Hendik, if he has submitted the document via application, and if it is vital, then non-consideration will mean the appellate order will be set aside.
But whether Malad, he has filed an application or that.
Yes, I have filed.
Where is the application?
Page 30, page 30. They have received it, my lord. Page 30. the left hand side bottom, they have received it, my lord. And the document is at page 32.
What is the document?
Page 32, my lord. The senior sub registrar has asked the labor to keep all this document in my residence.
So, why don't you just obtain some instruction? What is the problem if this document is taken on record? His only grievance is this document is not taken on record, that's all. Otherwise, what purpose will be served? The court ultimately will come to us and we will have to interdict. This kind of, tell the officers that this kind of rigidity is not good. Take it, you may agree, you may disagree, that is up to the
It is up
authority.
to, but Lord Lordship can dispose of my matter, my lord, that,
Then I'll record your submission that,
let me take instruction regarding.
That's
that.
what
It will
I'm saying.
better.
because then otherwise you will have to
Otherwise-
take the responsibility. You have heard Mr. P.K. Rochester, counsel for the petitioner. There was the amendments made in the writ petition. After hearing the preliminary arguments of Mr. Roy Chaudhary, Mr. J. Hending, Learned Standing Counsel, Revenue Department, Assam, is requested to obtain instruction as to whether the document at Annexure G, capital G, to the writ petition has been submitted by the petitioner before the appropriate authority, and if so, whether the same has been taken on record for the purpose of disposal of the pending appeal. One extra copy of the writ petition be furnished to Mr. Hendrick during the course of the day. Let this matter be listed for motion again after a week. You can also appraise us what is the status of the appeal.
Lordship.
Then Mr. Hendrick to also appraise this court as to the status of the pending appeal. Yes.
May I please your lordship? My lord, these two petitioners before your lordship,
Hmm.
they pursuant to an advertisement dated 26/22, page 19, my lord.
Hmm.
They applied for the Anganwadi worker post against, my lord, a particular center, my lord. Mentioned in there in my lord. They have applied it, and this kindly turn to page, my lord, 23, my lord, and 24, my lord. They have applied, this is received and acknowledged, my lord. Now, my lord, again they have filed an advertisement floated, my lord, at page 25, my lord, against the post, including this post also, my lord. Page 25, my lord, that is
No, but
26.
what is the grievance of your
Only,
client?
my lord, that, my lord, they are going to process already the process is started for the selection, my lord, but we are not included. And nothing, the advertisement is silent, my lord, regarding the earlier applicants, those who have already submitted the application. Only my prayer is that they may be directed to include us on the basis of our earlier application in the process of selection. Only this much, my lord.
Will this motion will post it after a week. You tell us what is, whether they have been allowed to participate, whether they have submitted their applications, and if so, whether
Yes,
they
Lordship.
heard Mr. A.K. Talukdar, learned counsel for the writ petitioner, also heard Ms. M. Bhattacharjee, learned additional government advocate, Assam, appearing for the state. The case of the writ petitioners is that although they had applied for the post of Anganwadi worker in terms of the advertisement notice dated 26/2022, issued by the CDP of Paschim Nalbari ICDS project, yet by issuing a subsequent advertisement dated 26/12/2024 for the same post, the writ petitioners have been prevented from submitting their candidature, hence this writ petition. Ms. N. Bhattacharjee prays for a week's time to obtain preliminary instruction in the matter. Prayer allowed, let this writ petition be listed for motion again after a week. 2 extra copies of the writ petition be furnished to Ms.
Yes,
Bhattacharjee
Lordship.
during the course of the day.
My lord,
Obliged, your Lordship.
Ah. What can be done here?
Lordship, he preferred an appeal, but that was not considered by the authority till date.
You obtain instruction. Just notice will issue. Not Mr. L.R. Majumdar and counsel for the writ petition appeals the amendments made in the writ petition. The primary grievance expressed in this writ petition is that by impugn order dated 01/02/2025, the petitioner was sent on compulsory retirement from service in a proceeding where proper opportunity for defending his interest was not granted to the petitioner. Full stop. Mr. S.P. Chaudhary and his counsel waits for some time to obtain instruction in the matter. NOM 6 weeks since Mr. Chaudhary has appeared and accepted notice for all the respondents, no formal notice, extra copies.
Extra copies.
Complaint.
May I please, your lordship? My
Yes.
matter is relating to compassionate appointment.
There is no compassion left. There is no appointment left. There is no compassion left. So there is no order left for you now. What to do?
Lordship, my name has
No, are you aware that all the compassion have gone for appointment? Are you aware of the notification? 8-9.
18-9.
18-9. No.
Lordship.
Oh, that's why you are here.
My case was earlier.
If you invite Mr. Bora to a cup of coffee, he will give you the copy of the notification. And then you will withdraw your petition. Compassionate appointments have been banned in this state by notification dated 18-9/2024. Do you have a copy?
Yes, sir. I can provide.
Give it to him. You examine that. Otherwise, the only order can be passed is dismissal. That's right, I have seen it, 2012.
2012.
On merit also you will not succeed, but now there is a complete ban. So we cannot even issue notice on the ground you have urged. And why this DLC is recommending names?
This was
Huh?
prior to that. That is.
No, what that is it? We will ask the chief
I agree.
secretary to file a name.
I agree. I agree.
Why, you ask them, why the DLCs and SLCs are recommending names after 2017? On the prayer of Mr.
GC Bora.
G.C. Bora and counsel for the petitioner. This matter is directed to be listed for motion again in the next week. Just to enable him to examine the legal issue arising out of notification dated 18-9/2024 issued by the state of Assam, imposing a ban on appointment on compassionate ground. You have a look at the notification and see whether you have any arguable case. Then we'll pass an order. Okay?
Item 18.
Anganwadi helper Millard. Advertisement was made Millard on 1/11/24. I applied 11 others Millard.
He is outsider, insider. Oh,
My lord,
no,
that's
I want the High Court to decide all
6
these
is
things.
outsider Millard.
Huh?
This 6 is outsider and moreover she is a Millard, a student of a higher secondary school, regular student.
Respondent number 6 has been already selected.
I am informed, but no list has been published till date Millard.
Huh?
I have been informed by other persons, she will be selected.
She may be selected.
Maybe, but
Then we may dismiss your petition on that ground.
of course.
You cannot come to the court, she may be selected. And what do you think this is? A travel agency? What do you mean by she may be selected? Why have you come to the court by filing this writ petition? You don't even know whether she has been selected or not.
Now I am informed, Lord.
You
So
don't
I
have
have
any
to
cause of
go-
action.
there is no list, Lord.
Or I will close it, granting liberty to you to approach at an appropriate time. If she is selected and appointed, then only you will have a cause of action, if at all. Today, what is your cause of action?
She may be selected and against the same post, Miller, where I am qualified.
Mr. A. Rashid Lanik, counsel for the petition. You have any-
Sharma, for respond numbers 1
you
to
have
5.
any difference in opinion?
No,
Anything?
Lordship.
Huh?
No, Lordship, we don't have instructions, but she may be selected, she may not be selected.
Ms.
So
E.
that is-
Shurmal and G. Assam has appeared for the state. Mr. Mr. D.K. Royal and counsel is present on behalf of the respondent number 9, that is Seba. The petitioner had submitted her candidature for appointment in the post of Anganwadi worker,
Helper.
Anganwadi helper in the Badang Donga Tiniali bracket general Anganwadi center. Full stop. Apprehending that the respondent number 6, who is who belongs to another locality and is not qualified for appointment to the said post, is likely to be selected. the writ petitioner has approached this court by filing the writ petition. Full stop. From the averments made in the writ petition, it is apparent that the writ petition has been instituted merely on the basis of apprehensions which are not founded on any material facts. Ms. Sharma, learned G. Assam, has also submitted that the writ petition is premature. Such submission of Ms. Sharma is found to be acceptable by the court. As such, this writ petition stands disposed of as premature. Writ petitioner would, however, be at liberty to approach this court as and when a proper cause of action arises in this regard. Yes.
Item 19.
So some 41,000 people are there in this. How many petitioners?
1800 something, Lordship.
Huh?
1800 something.
1800 petitioners and the council is missing, disappeared. If the 1800 people come to know about it, then he will be in serious trouble. Where is this Abu Nasir Uddin Ahmed Petitioners Council? They will hound him down now if we dismiss it. One more chance, then Petitioners Council is absent when the matter is called up. Mr. C. Sharma, Learned Standing Counsel, what WR Department is present. However, since the Petitioners Council is absent today, this matter stands adjourned for 2 weeks.
Item 20.
May I please listen? The matter pertains to the, my wife's name has been wrongly recorded in the service book.
What is her date of retirement?
He's retired on 1/7/1998 and.
1998 he retired.
It is retired.
Now you want it to be corrected.
His wife's name has been corrected because his wife's name is wrongly recorded as Eli Soikia, where her original name is a Beauty Soikia, and his date of birth is wrongly recorded. So I have submitted my representation.
Recipient of family pension.
No. I have recorded my wife's name as a correct name in my service book.
Pension paise koi ase.
He's retired from service.
We are asking whether your wife, why the petitioner is a recipient of family pension.
No.
You are saying husband is retired.
No. Petitioner is retired. He is alive, but in a service book.
We issue rule. It will be heard in due course because he is unable to even understand what the court is asking.
No. Family pension is a no.
So what is the problem? Why you want it to be corrected?
Corrected because his name, her name was a originally.
Will
a Beauty Soikia.
Heard Mr. Chetri, counsel for the petitioner, peruse the averments made in the writ petition. The husband of the petitioner was serving as a Havildar under the Indian Army, has retired from service with effect from 1/7/1998. The petitioner, being the wife, has approached this court by contending that her name has been wrongly recorded in the service record of her husband. Hence, the prayer is for issuance of a direction to correct the records. Mr. Ms. B. Sharma, Learned CGC, prays for time to obtain instruction in the matter. NOM 8 weeks since Ms. Sharma has appeared and accepted notice from the respondent, no formal notice, extra copies, etc., etc. You are unable to even say what is your case.
No.
Why you want it to be corrected after so many years?
Because my wife's name is in the admit card and other document is a reflected is a Beauty Soikia.
Petition
It's on page 3.
the petitioner approves this court for correcting the name of his wife
Why?
recorded in the service book.
For other document, her name is a Beauty
So as to
Soikia.
avoid any future complications in the matter.
Item 21.
May I please,
Yes.
Lordship? This matter pertains to non-payment of family pension. The father expired in the year 2021. The petition number 2 is minor, so he is represented by his sister, petition number 1.
Which department?
Excise department, my lord. He was working, father working as a constable in the Superintendent Excise Borpeta.
Why the family pension has not been given?
My lord, there's a dispute between the petitioners and the second wife of the deceased.
No dispute, my lord. For a moment, if you
Just a
lordship,
minute, just a
page, page number 33.
Just a minute, the court is asking a
Yes,
question to her.
yes,
You take
yes.
your seat,
Yes, sir.
don't interrupt. What is the dispute? Dispute is with whom?
Lordship, the deceased excise employee, his first wife also expired. So thereafter, he married the second time. And the
So the
petitioners
petitioners are the children born through the first
are
wife.
first wife. Yes, your lordship.
Then we
And they
to issue
have
notice.
said that they have submitted a representation before the concerned authority. But here in the postal receipt, your lordship, that is in page number 42, the address is incorrect. Of the concerned authority is the Commissioner of Excise.
Mhm.
They have written to both the Commissioner of Excise and the Superintendent. But the address of the Commissioner of Excise is incorrect, your lordship. But I'll still get
All
my
right,
instructions. your
since
lordship.
there is a minor here, we will look
I'll
into
get
the
my
matter and
instructions,
see,
Your
but the notice has to go.
May I submit one thing?
Yes.
The mother of the petitioners expired in 2019. Thereafter, our father married to respondent number 5.
Hmm.
And after expiry of our father, the second wife, respondent number 5, submitted 4 applications before the authority. For a moment, if your lordship peruse page number 33 and extra 13, in the last paragraph, it is clearly mentioned that in this connection, one official hearing was held with the aforesaid family members of late Moon Talukdar, and they eventually consented to accept all the benefits in equal parts. There is no conflict of interest, my lord.
So you want the final order to be passed today itself?
No, lordship. No,
Notice to be
my
issued.
learned friend said that we have some dispute. We don't have any dispute, my lord.
Let her come, she has to come and say there is no dispute. Then you can take this plea that earlier you said this, now today these submissions
No,
are.
I am not.
So let us issue notice.
Lordship.
When did the father expire?
2021, my lord, at 19/3/2021.
All right. The writ petitioners herein are the offsprings of a deceased government servant who expired on 19/3/2021. This is government servant serving under the excise, serving in the establishment of Superintendent of Excise, Borpeta, who expired on 19/3/2021. Full stop. The first wife of this is government servant through whom the petitioners were born had predeceased him on 15/9/2019. Full stop. Thereafter, this is government servant had married the respondent number 5. Full stop. The petitioners are claiming that you're right. The petitioner number 2 is the minor son of the deceased government employee who is being represented by his sister, unmarried sister. That is the petitioner number 1. The grievance of the petitioners is that although they are entitled to receive family pensions, no such pension has been granted till today. Miss M. Kalita, understanding counsel for the respondent this is which department? Excise department.
All except 5, your lordship.
Submits
Except
that apparently due to a dispute between the petitioners and the second wife of the deceased employees, the family pension could not be released. She, however, seeks some more time to obtain complete instruction in the matter. Full stop. Mr. Bhattakur has, however, disputed the assertion that there is any dispute amongst the petitioners and the respondent number 5 on the issue of release of family pension. Be that as it may, on the request of Ms. Kalita, 4 weeks time is granted to obtain instruction. NOM 4 weeks. Since Ms. Kalita has appeared and accepted notice for respondent numbers 1 to 4, no formal notice to the said respondents. Extra copies of the writ petition requisite in numbers be furnished to the learned departmental counsel within 3 days from today. Petitioner takes steps for service of notice upon the respondent number 5 by registered post with AD. Full stop. Considering the nature of issue involved in this writ petition, an attempt to be made to dispose of the writ petition expeditiously, preferably at this stage of admission hearing. parties to come prepared accordingly.
I'm grateful, Your Lordship.
My lord, to withdraw the benefits of retention of golf accommodation.
So another matter has been,
Yes,
ma'am.
lordship, your lordship also passed similar order, my lord.
yes, what do you have to say?
My lord, similar matter is pending, my lord. Let the matter come along with this matter.
Take down, heard Mr. Ellen Dehingia, learned counsel for the writ petitioner. Also heard Ms. A. Gayan, learned CGC appearing for the respondents. Full stop. The writ petitioner hearing is serving as deputy commandant and is posted at the 54th Battalion, SSB, Bijni, Chirang, Assam. Full stop. The grievance of the petitioner is that on account of the OM dated 6/10/2022, the grievance of the petitioner expressed in this writ petition is to the effect that owing to the OM dated 6/10/2022, withdrawing the benefit of general pool residential accommodation at New Delhi, the residential accommodations availed by his family members at Delhi pursuant to his posting in the NER Northeastern region would stand expired on 25/3/2025.
Lordship.
Full stop. Mr. Dehingia submits that similar writ petitions raising similar nature of grievance have already been admitted by this High Court, wherein interim orders of protection are operating. Therefore, a similar order be issued in this case as well. Ms. Gayan Lanes CGC has fairly submitted that a batch of writ petitions are already pending with the same issue. Therefore, the matters be clubbed together. Full stop. In view of the above, NOM 4 weeks since Ms. Gayan has appeared and accepted notice for all the writ petitions. For all the respondents, no further notice, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned department counsel office to list this case along with WPC number 4696 of 2024 and the batch of connected writ petitions. Stop hard on the prayer of interim relief. Stop having regard to the facts and circumstances of the case as well as the earlier orders passed by this court on the same issue. It is hereby provided that no coercive action shall be initiated against the writ petitioner in terms of the OM dated 6/10/2022 until the returnable date.
May it please your lordship. The petitioners applied for constable tradesman in border security force in the year 1617. Their process was cancelled according to the petitioners came before the honorable court by filing WPC number.
Obtain instruction at motion
Lordship,
stage.
page 42, we have already submitted. High Court's order is of 25/7/22. On 15/9/22, we have given the reply to his representation that at page 47, the entire selection process has been cancelled.
There has been impunity security, lordship.
Then what is
That
to be
order
done?
has an impunity security, lordship.
They can't cancel the selection process.
Lordship, there are some direction from this honorable court observation that we should file our representation and court shall consider it is on the basis of an order of the honorable Gujarat High Court. I am reading that.
No, but they have cancelled the selection process.
If that selection process was cancelled much prior to that, after that this High Court gave the order to consider our representation on the basis of a Gujarat High Court judgment that since there is no irregularity in this state, so the petitioner's representation may be considered. That cancellation order did not consider the High Court's order.
Relief you are now seeking.
Lordship,
For you, for some of you, the selection should be
my
conducted.
prayer is that ultimate prayer. Our representation may be considered on the basis of the High Court's order.
I am dismissing your petition. You make your submission for another 5 minutes. Why do you file these petitions? When the selection process has been cancelled, your writ petition will be dismissed, you know that. You want
Lordship,
an order, you want to want a dismissal order or you want to withdraw, that is your call.
Lordship, give me 5 minutes, I shall try to consider also. Lordship, I come to page 41,
Yes.
Gujarat High Court's order.
Hmm.
That is the relevant portion.
Yes.
Paragraph 27, fourth line from fourth line. However, the court deems it fit to observe that considering the young and only petitioner left out and the fact that to the extent that the inquiry by the BSF and the investigation by the CBI, which has progressed till date, does not indicate any illegality in the center where the petitioner appeared, the court leaves it open for the petitioner to make the representation to the respondent, BSF to treat the case of the petitioner in special facts and circumstances, and if any vacancy is still available, then consider the case of the petitioner in accordance with the law and communicate the outcome of the petitioner at the earliest. Now, on the basis of this order, our High Court passed the order at page 29, Lordship will find.
Page
29, Lordship starts from page 28, para 10. In the circumstances, we are unable to find any merit in the petition requiring an interference with the decision of the respondent to cancel the selection process. But however, as submitted by Mr. A. Mubarak, learned counsel for the petitioner, as provided in the Gujarat High Court in its judgment dated 18/7/2022, Pal Bikram Ramesh and 2 others versus Chairman Recruitment Board and 2 others in our special civil libel number 81895/2017, the petitioner also given the liberty to file individual applications before the resolution number 4. If so advised, and upon such application, necessary orders hereon may be passed. Now, Lordship, we filed our representation. Only thing that while rejecting, even if it is rejected, while rejecting the application, it should be given weightage to the order of the High Courts that this person's there was no illegality in this sentence, and these persons could not be appointed for such and such reason. But that has not been given in the rejection letter, but in the impugn order. That is my case in brief, Lordship.
All right, you still have 3 minutes before I start dictating the order of dismissal of the writ petition.
In this rejection letter also, Lordship, only thing that part was not considered. Since it's a simple case, it is the case of the respondent in the repression also. Same facts has been narrated only since it is cancelled, therefore they could not be given. But the question is that if there is some vacancy, then consider them. This part is not reflected in this order.
And where is the disposal of the representation?
This is the order.
15/9/22.
Where is
Starts
it?
from page 42. We have
This is the order.
considered the case judgment order of this Honorable High Court. Starts from page 42. Honorable High Court's order considered at page 43.
All right, take down. Yes, anything else?
No, Lordship.
Heard Mr. R. Sharma, learned counsel appearing for the writ petitioners. Also heard Ms. B. Sharma, learned CGC appearing for the respondents. Full stop. The 4 writ petitioners have approached this court by filing this writ petition inter alia, praying for setting aside the order dated 15/9/2022, issued by the respondent number Who had issued the order?
Lordship,
15.
Deputy Inspector General is
He's
responsible
not
number
even a
three.
party here, is it?
That is not any.
Inspector General Frontier Headquarters, it's number 3.
He's not a party here.
Oh, no, so it is issued on behalf of Inspector General, page 47. For Inspector
Issued by
General.
the
Frontier
respondent number
Headquarters,
3.
yes.
Issued on
On
behalf
the-
of the respondent number 3, rejecting the representation submitted by the writ petitioners along with 86 others.
See, it's 9 others.
Huh?
9
Total-
others.
Huh?
9 others.
Along with 9 others.
Yes, Lordship.
The
No,
facts of
it's
the
11 actually, I'm sorry.
In a
Page
nutshell.
42, 11 others.
is that the Border Security Force authorities had earlier issued advertisement notice dated 21/5/2016, inviting applications from the male citizens for filling up 561 vacancies of the post of constable bracket tradesman in the BSF for the year 2016-17. The writ petitioners had participated in the said process. However, the selection process was eventually cancelled by the BSF authorities after detecting certain irregularities to anomalies in the process. Full stop. Being aggrieved by such decision of cancellation of the selection process, the present writ petitioners, along with total 11, so here there are 4,
There is 4 total 12. So 8 others.
along with 8 others, had approached this court by filing WPC number 1322/2017. Full stop. After examining the matter, this court had passed order dated 25/7/2022, dismissing WPC number 1322/2017 by holding that there was no merit in the writ petition. However, taking note of some observations made by the High Court of Judicature at Gujarat in the case of Pal Vikram Rameshbhai and 2 others versus Chairman Recruitment Board and 2 others. Special Civil Application number 1895/2017, page 30, Prabhu, I read, whereby the Gujarat High Court, while dismissing similar writ petitions, had made an observation that it will be open for the petitioner therein to make a representation to treat his case in the special facts and circumstances, and if vacancy is still available, then to consider the petitioner's case in accordance with law. The learned single judge had made the following observations in the order dated 25/7/2022, which are reproduced herein below. Page 28, para 9. Okay, para 12 look at quote korbo, page 29. Full stop. Next para. Pursuant to the order dated 25/7/2022, the petitioners had submitted a representation before the respondent number 3, ventilating their grievance in the matter. However, after examining the issues raised by the petitioners, the said representation was rejected primarily on the ground that since the selection process was cancelled due to malpractices, hence, there was no scope for the authorities to redress the grievance of the petitioners in that regard. Full stop. Representation to be submitted by saying what? What was your representation?
That is not available. because
Representation
after
not
the High
annexed.
Court's order.
Huh?
Representation is not annexed.
What representation? With all respect, the learned single was dismissed your petition and said, how can people be appointed when the selection process? However, since the copy of the representation submitted by the petitioner is not available on record, it is not clear as to what exactly was the prayer made by the petitioners before the authorities. Full stop. The present writ petition seeks to assail the order dated 15/9/2022. Full stop. After hearing the submissions made by learned counsel for the parties, this court does not find any justifiable ground to entertain the writ petition. Full stop. Firstly, since the selection process itself was cancelled, the question of appointing the petitioners would not arise in the eyes of law. No such direction was also issued by the learned single judge by the order dated 15/7/2022. Full stop. Since the petitioner's representation is not available on record, it is also not clear as to what was their prayer before the authorities, which was rejected by the impugned order dated 15/9/2022. Full stop. On a careful reading of the amendments made in the writ petition, this court is also of the opinion that there is no right of the writ petitioners that can be enforced in the present proceeding. Under the circumstances, this court is of the unhesitant opinion that there is no scope for the court to grant any relief to the petitioners in the present petition. Consequently, the writ petition is held to be devoid of any merit and the same is accordingly dismissed. Next matter, please.
Obliged, Lordship.
I think motion matter 5 to 9.
Yes, Mr. Decker,
Maybe allowed to withdraw also with liberty.
you want to withdraw? Who is for the other side?
Mr. Yes.
5 and 9, and access Roy appearing for
Acha,
6, 7, and 8.
Item 5 and 9, Ms. S. Borua, CGC, and Mr. S.S. Roy, CGC, for item number
6, 7, and 8.
6, 7, and 8. So order will be separate, but same order. Had Mr. A. Decker, learned counsel appearing for the writ petitioner. The learned CGC has appeared and submitted that since the records were maintained by the BSF authorities,
Assam Rifles.
by the Assam Rifle authorities and the Assam Rifle authorities, hence, it is the said authority which would be in a position to respond to the allegations made by the petitioners. However, in the absence of proper pleadings and since Assam Rifles authorities are not parties to the writ petition, the proceedings itself would not be maintainable. At this stage, Mr. A. Decker, learned counsel for the petitioner, seeks leave of this court to withdraw the writ petition with liberty to file afresh after rectifying the defects in the writ petition. The prayer is not opposed by the learned CGC. Hence, the same stands allowed. Writ petition stands disposed of on withdrawal with liberty as paid for. Same order will be passed. Khali names of CGC will change. Yes.
Obliged.
For admission, item 24.
May I please announce?
Yes.
My lord, this is against an endorsement, my lord, that is at page 39, my lord. Whereby, my lord, the district transport officer, he has issued this, my lord, to the, my lord, insurance investigator where my vehicle is, my lord, for damage is pending, my lord. Where it appears that, my lord, transport validity is 17/11/2013. In fact, my license was renewed, my lord, till 2017, my lord. So this is my, my lord, limited prayer, my lord. And this is in respect of, my lord, authorized to drive, that is motorcycle, LMB, MGB, HGV only, my lord. So in fact, this is not disputed only, my lord, with regard to the date, my lord. That is, my lord, renewed, my lord. My license was renewed after this 17/11/2013 up to 2017.
Lordship, here, Lordship, I pray for some time, Lordship, the report has not received by us, Lordship. 1 week time may be given for.
What report?
The report for inquiry report from the CID, Lordship. Last order, Lordship, 2524. Lordship. As per last order, Lordship.
You are appearing for whom?
I'm for CID, Lordship.
CID.
Lordship.
There is an interim order here.
Interim order is not there.
There is no interim order, ma'am. Because the license is fake, lordship, thereafter this honorable court has directed the CIT to make an inquiry. This report is awaited, and last occasion direction was given to the government to file an affidavit next in report.
The report will be necessary.
In fact, it's, my lord, not fake. My lord, what has happened in this case, my lord, the renewed, my lord, license was, my lord, issued by the authority, inserting, my lord, one PSV option, my lord. That was not applied for by the, my lord, petitioner number 1, my lord, 2, my lord. So because of that, my lord, court directed that how PSV has come in your license. So that is the issue why court directed for an inquiry by the CID, my lord.
All right, but since this inquiry is conducted, the report has to be now
Yes,
submitted.
Lordship.
What is the ultimate relief that you want here?
In fact, my lord, I am just, my limited prayer is that, my lord, only, my lord, that what transport validity is 17/11/2013. In fact, that was till 2017 in my renewed license without PSV. So that is my limited prayer. I don't want this PSV option, my lord. That was inserted by one authority, my lord, inadvertently, probably by the officials. So that is, I don't, pilot. I even didn't apply for this PSV option, but somehow it came in my
What is
license.
PSV?
That is public service vehicle.
And the vehicle, your vehicle is what vehicle?
That is motorcycle, LMB, MGB, and HGV. That is Bolero pickup vehicle. So I didn't want.
It had met with an accident.
Yes, man.
Then what happened?
So my claim is pending before the insurance authority for them as well.
And who is appearing for the insurance?
Insurance is not made party here.
Insurance is not made
made party. Because ultimately, DTO has issued this, my lord, communication.
So you then think about it. You may have serious problems here.
Yes,
Without
yes.
insurance being made a party, you have got an interim order which you are not even aware of. Forget them. You are also not aware that there is an interim order in your favor. You are not aware.
Not aware, my lord.
That's what happens. The order dated 3/1/2018. Have you read that order? 3/1/2018.
Yes, my lord.
You don't know.
Yes, yes, no.
Check it once. It will help you someday.
Yes, ma'am.
But we'll adjourn it for 3 weeks. So as to enable, heard Mr. J.C. Bora, learned counsel for the petitioner, also heard Mr. S.S. Roy, learned G. Asam, appearing for the state, who seeks further 3 weeks time to obtain the report of the CID and place the same on record of this case. Ms. M.D. Bora, learned standing counsel, Transport Department, Assam, is present for the respond numbers
1 to 4.
1 to 4.
Okay.
Let the matter be listed accordingly.
My lord, then interim shall continue till then. If
First, you find out,
Yes,
but
yes.
you don't even know that there is an interim order.
Yes,
And that interim order can never be implemented because the insurance is not a party.
Yes, yes.
So another 2 years after that, we'll discuss. Lots of things to be done here.
Yes, yes.
You missed the bus. Anyway.
Yes.
Then lordship, the direction from this honorable court to present the petitioner in person before this honorable in each and every day.
He appeared, my lord. He appeared earlier, my lord.
CID inquiry report was produced before the court and it was.
All right, you bring your
Lordship.
statement and we'll
Yes.
pass an order.
May I please your lordship, the matter has become infectious, lordship.
All right. Why it has become infectious?
It's a pending matter, lordship.
No, pending
pending
matter, all
matter-
pending matters are not infectious.
And
Little support from you would be so nice. Compensation.
lordship,
Why it has become infectious? The compensation has been received. Acha, Miss F. Begum, your Miss F. Begum,
Begum.
Learned counsel appearing for the writ petition has submitted that she has instructions from her client not to press this writ petition. Ms. C. Borwal, Learned CGC, S. Borwal, Learned CGC, a state of Assam. Who is for the state? Mr. D. Bora Learned G. Assam. Acha, you are for Assam.
Yes. Number 3. This is
And-
bench 5 meter.
Acha, okay.
Other standing counsel is there.
Ms. S. Borwal, Learned G. Assam is present for the respondent number 3. Run has appeared for the other respondents. In view of the submission made by Ms. So-and-so, this writ petition stands disposed of as not passed.
Item 28.
28 has been mentioned. 20?
25. I'm sorry.
Lordship, kindly pass over the matter for the time being, Lordship.
What is the matter about?
This matter,
What is your case?
this matter relates to refixation of revenue for the fishery matter. What happened in this case? The petitioner has run the fishery for 5 months, but the
What
authority.
is PCV?
Fishery matter, fishery.
Fishery.
Yes, ma'am. Petitioner has run the fishery for 5 months, but the authorities are demanding the revenue for the whole year, ma'am. If Lordship may.
So have you submitted any representation?
Yes, my lord.
Where is it?
Representations are submitted, my lord. They have also, but they have not considered, my lord.
Where is your representation?
First is at page 29, my lord. Then, my lord. And lastly, on page 31, my lord.
One representation is page 29. Where
Yes,
is the
and,
other?
and then, my lord, page 30, almost same. The lordship may kindly see, my lord, page 31, my lord.
So that settlement was done many years back.
Yes, my lord.
Which year?
My lord, it was done on, my lord, the original settlement order was issued on 29, 2017. My lord, we may come to page 11, my lord. Page 11 is the original settlement order. Then,
So now the period of lease is over.
no, my lord, what happened, my lord? He has, the petitioner is not able to pay the revenue and whatever the other demands, my lord. That's why his settlement was cancelled, my lord. So that part is gone. I'm not into this, only for this part.
No, settlement was cancelled when?
My lord, settlement was cancelled on 28/5/2018.
Where is the order?
My lord, that order in the item next item, my lord. Item 30, my lord, that is at page 42, next petition, my lord, that is 3594, my lord. Page 42, my lord.
Who is your senior?
P. Sharma, Lordship.
Tell him to come.
Yes,
Disposing
Lordship.
of this matter.
Yes.
Call him.
Yes, Lordship.
Page
All right.
40
Where is he? Where is he?
It's in division bench, I guess, Lordship.
Division bench, which item?
I can,
Which
Ah.
item?
I have to see, Lordship. I will-
See, tell us which item is appearing.
Yes, Lordship.
Division bench, we know which item is going on. Call him here.
Page-
Or else you tell him that both these writ petition will be disposed of by asking the authorities
Yes,
to
yes,
look into his grievance.
Yes. All right.
Page 42.
Page 42, my lord.
Then what has happened? There is any recovery from you?
No, my lord, they have not issued any recovery since these petitions are pending, my lord. And my lord, with regard to payment, my lord.
So there is a demand of 6,67,000 from you.
6,67,000. What happened, my lord? The total annual revenue is 12 lakh. My lord, total annual revenue is 12 lakh 65, my lord.
Hmm.
So they have till, it becomes around about, my lord, 1 lakh 5 rupees per month. So since 7 months, I have not almost run, my lord. So that's why this 6,07,000, my lord. Although I have paid, my lord, 5 lakh 50,000, my lord. But I have run only for 5 months, my lord.
That's all right, but is there any provision for refixation?
My
And
lord,
your representation is pathetic. Submit a fresh representation.
Because, my lord, apparently they have, what happened, my lord, after passing the settlement order, they have stayed the order because there is one case pending. Ultimately, the position of
So
the.
let the authorities look into his
Yes.
grievance. Let him file a fresh representation.
Yes.
And subject to the outcome of the representation, further actions in accordance with law may be initiated. That being said.
Actually, the matter may.
Matter may.
Okay, Lord. I have not gone through it.
So in this writ petition, you have challenged the order of cancellation.
Second one.
Second one.
3594, my lord. I'm not on that, my lord, because that part is over, my lord. I'm not going
So
to.
we'll dispose of both the writ petitions.
Yes, lordship may dispose, but with regard to cancellation, I have no grievance at this.
All right, let him file a fresh representation and the MD will look into his grievance and pass appropriate orders.
Oh, obliged.
Or Mr. A.K. Gupta, Learned Counsel, appearing for the writ petitioner in both these writ petitions. Also heard Mr. P. Sharma, Learned Standing Counsel. This is AFDC.
Lordship.
AFDC, appearing for the respondents. All the respondents?
All the respondents, Lordship. This department is also there. I
For
will.
the respondents. Full stop. These two writ petitions hinge, H-I-N-G, hinge around common question of law and fact, and therefore are being taken up for disposal by this common order. Full stop. Pursuant to the NIT dated 11/8/2017, issued by the respondent number 2, inviting bids for settlement of within force, Mayor-Logona-Khona Fishery stroke bill, unquote, for a period of 7 years. The writ petitioner had submitted his bid, whereafter the fishery was settled with him for a period of 7 years. That is, with effect from 2017-18 to 2023-2024 at the annual revenue of rupees 12 lakhs 64. Full stop. Thus, the total revenue payable by the petitioner for the period of 7 years as per the order of settlement was rupees 84 lakhs 448. Full stop. The petitioner's case is that due to pendency of court cases, there was delay not only in execution of agreement, which could be done, execution of settlement agreement, which could finally be done only on 27/10/2017, but even the handing over possession of the fishery got delayed. Full stop. Even after he took possession of the fishery, the same could not be operated due to encroachment and other operational reasons. Full stop. The claim of the petitioner is that in the first year, out of 12 months, the petitioner could operate the fishery only for a period of
5 months.
5 months. Full stop. Since the petitioner could not operate the fishery as per the terms of settlement, hence he defaulted in payment of revenue, as a result of which, by the order dated 28/5/2018, passed by the respondent number 2, the settlement of the fishery was cancelled and the petitioner was asked to deposit a sum of rupees 6,67,090 without fine, bracket of without fine, full stop. Due to the delay in handing over possession of the fishery, the petitioner had submitted two representations. One dated 3/11/2017, bracket annexure E to WPC number 3503 of 2018, and another dated 9/4/2018, bracket annexure E1, bracket close, making a request for refixation of revenue of the fishery, full stop. Since the prayer made by the petitioner was not considered, he had approached this court by filing WPC number 3503 of 2018, seeking a writ of mandamus, directing the respondents to readjust to refix the revenue of the fishery by considering the representations submitted by the petitioner. Full stop. During the pendency of WPC number 3503 of 2018, the cancellation order, cancellation of settlement was made on 28/5/2018, aggrieved thereby. WPC number 3594 of 2018 was instituted by the writ petitioner. Full stop. Mr. Gupta, learned counsel for the writ petitioner, has argued that his client is not pursuing the challenge made to the order dated 2/8/2018, by means of which the settlement of the fishery was cancelled. His only grievance is pertaining to the failure on the part of the respondents to consider his representations for refixation stroke readjustment of the revenue due to the delay in handing over possession of the fishery. Full stop. Mr. Sharma, learned standing counsel AFDC, has submitted in his usual fairness that since the petitioner has submitted a representation, the same deserves consideration by the authorities. However, as per the materials on record, it appears that no such consideration has been made till today. As such, Mr. Sharma has submitted that if a direction is issued by this court, the grievance of the petitioner will be looked into and appropriate steps as may be permissible under the law would be taken in the matter. In view of the above, and as agreed to by learned counsel for both the sides, without expressing any opinion on the merit of the claim made by the petitioner, both these writ petitions are disposed of by granting 4 weeks' time from today to the petitioner to submit a fresh representation by enclosing a copy of this order, ventilating his grievance in the matter. If such a representation is submitted by the petitioner before the respondent number 2, that is the managing director of AFDC, the same be looked into and be disposed of by a speaking order. First of any action in the matter proposed by the authorities be initiated only after the representation submitted. Now, if so advised, be initiated only after such representation submitted by the petitioner is considered and disposed of in accordance with law. Writ petition stands closed. Stand closed. Obliged.
This item maybe pass over the time, my lordship.
No Passover timing, then pass over for the day. Why Passover for time being?
My senior is in court number 1, lordship.
Then you are here. We can't upset our.
22.
Which item is your senior?
11, lordship.
Huh?
This item is going on, 11 item.
What is the matter about?
This is the challenge, this disability candidate which adjusted, who is passing in merit, lordship.
What is the
Well,
matter?
this is they're challenging that the APSC has violated the Disability Act, and the petitioner being a disabled candidate was to be adjusted against a post of assistant engineer advertisement floated by APSC. But well, interestingly, they have not the Department of Social Justice, as though it is implemented, they have not served copies upon them.
Will you serve copy? Learned counsel for the petitioner, also had Miss D. Jane, learned counsel appearing for the Department of Social Justice, who submits that respond number. Department of Social Justice, which has been newly implemented
Yes, Lordship.
as respond number 7, who submits that no copy of the writ petition has been furnished to her. In view of the above, petitioner's counsel to furnish copy of the writ petition to Ms. Jane within 3 days from today, so as to enable her to obtain instruction. Mr. D. Gogoi, learned
PH.
learned standing counsel PhD. Ms. P. Sharma, learned standing counsel APSC. And Mr. S. Datta, learned standing counsel PNRD Assam, and Mr. D. Bora, learned G. Assam, are present on behalf of the respective official
Date
respondents.
may please, Lordship.
In the month of May. Second week of May, list again in the second week of May 2024, 25.
Item 45.
Not appears for the petitioner on call, Mr. D. Bora, Learned G. Assam is present for the state. Since the petitioner's counsel is absent today, let this matter be listed again in the second week of May 2025.
Please, Your Lordship, my lord, the matter may kindly be taken after 3 weeks, my lord. We have to take instructions.
The prayer of Mr.
P. Colleague.
P. Kolita, learned counsel for the writ petitioner. This matter stands adjourned for 3 weeks so as to enable him to obtain instruction. Who is there for Mr. N. Kalita, learned counsel is present for the respond number 1. Anybody else appearing?
My lord, Mr. D. Gogoi appears, my lord, in this matter, my lord.
For whom?
For ATCL, my lord.
Respond number 2.
Respondent number 2.
And Mr. B. Gogoi, this learned counsel is present for the respond number 2.
Obliged, my lord.
Item 37.
Yes, what is the matter? It will take some time.
Yes, ma'am.
Then we'll take it after the other matters are over. Or you want it to be taken on a non-miscellaneous day?
On other team.
Today, I am ready. I am not ready. Right now. So let these other matters be over then, or you can take it up tomorrow if you want. Tomorrow.
Tomorrow I've got another.
How long will it take? How long?
Depend upon him, man.
What is the matter about?
Matter is about disciplinary proceedings where the penalty was given for downing, that is stoppage of 2 increments without cumulative effect.
This will take time.
My lord. My lord, or otherwise on 1st of April, my lord, Tuesday.
Your lordship, it has already taken 3-4 months by adjournments.
No.
I want to finish it.
You may want many things. Your want alone will not matter. You wait, we'll see if it is possible. After other cases are over, we'll take it.
Tomorrow I've got another case, otherwise I would have agreed for tomorrow. In the I could
do your other case, go and do. Let's see what happens after other matters.
Lordship, in this matter, record was called for lordship, so it is awaited lordship. Kindly allow me another 1 week time.
Or after the vacation, my date may be fixed.
Mr. S. Khan, learned counsel is present for the petitioner on the request of Ms. N. Bhattacharjee, learned additional senior government advocate Assam. 3 weeks further time is granted to her to obtain the records. Accordingly, let the matter be listed after the Bihu vacation.
May I please, your lordship? Your lordship, in this matter, your lordship, I have challenged the findings of the inquiry report, your lordship, the dismissal order, your lordship, and the dismissal of the appeal, your lordship. Lordship, the respondent number 4 has filed their affidavit in opposition, your lordship, and I need not have to file any affidavit in reply, your lordship. So perhaps this matter may be fixed for admission hearing, your lordship.
Mr. D. Decker, learned counsel for the petitioner, submits that that he is in receipt of a copy of the counter affidavit filed
on your lordship 27, 2000.
Filed on behalf of
the respondent number 4, the
respondent number 4. And no rejoinder affidavit is called for on behalf of the writ petitioner as such. Now, Mr. Deca has therefore requested that the writ petition be taken up for disposal at the stage of admission hearing. The said prayer is not opposed by Ms. Bhattacharya. However, she seeks posting of this matter on some other day. Is it? Are you ready
Lordship,
to-
because respondent number 5 will be filing because his affidavit is necessary.
Who is for respondent number 5?
SP Lordship.
Huh?
SP.
Who is
So-
appearing for him?
Lordship, I am appearing.
What is the matter about?
This is dismissal, Lordship. Disciplinary proceedings was there. So this was taken up by the SP concerned Lordship, and the affidavit file is by the appellate authority only,
Yes,
Lordship.
correct.
So this
All right,
is there.
since it is a case of dismissal from service, on the request of the petitioner's counsel, list this case for final hearing as a fixed item on 10/4/2000.
Lordship.
Much obliged, Lordship.
Deeply.
May I please your lordship?
Yes.
Lordship, in this matter, lordship, I am praying for an adjournment, my lord. Lordship may fix the matter after the Bihu.
Why?
Lordship, petitioner was retired, my lord,
Hmm.
and he was playing for regularization, my lord. Although he was retired, my lord, so government has decided, my lord, his case was placed before the cabinet, my lord, and some queries were there, some process are going on. my lord.
Lordship, item 40, this is not placed before the cabinet, Lordship. Item 41 was filed by the petitioner while he was in service, Lordship. And after, during pendency of this case, he was retired. And after retirement, Lordship, he was served for 29 years, Lordship. And after that, Lordship, he filed, Lordship, this item 40, Lordship. Even though, Lordship, he is not, Lordship, service was not regularized, Lordship, he is entitled for pension, Lordship. This is my case, item 40, Lordship.
So you want it to be finally decided today? No, say that. Otherwise, he is asking for time.
Yes, ma'am.
Then before.
Either say that don't give them time.
Before,
Don't let the cabinet examine anything.
before vacation, Lordship.
That I cannot say. You argue today then. You may or may not get an order. If you are confident, then you argue.
Lordship.
What is that you want?
Lordship, as my friend is asking time, Lordship. Around.
Time should be given.
Lordship.
That's what I suggested in the beginning. You opposed.
Yeah, Lordship.
Now I am saying argue the matter. You are saying give him time. Make up your mind what you want. Heard Mr.
AMS Majumdar.
AMS Majumdar and counsel for the petitioner. Also heard Mr. S. Dutta Lana, standing counsel for the.
My lord, in this case, I am appearing on behalf of Mr. K. Kaur, my lord. He is appearing as additional AG, my lord.
Then are you authorized to appear in this?
Yes,
case?
my lord.
Appearing for the departmental authorities who submits that considering the peculiar facts and circumstances of this case, the matter is now being examined at the highest level
My lord.
by placing the same before the cabinet.
Yes, sir.
Therefore, 4 weeks further time be granted so as to obtain for updated instruction in the matter.
My lord.
First, since the prayer of the petitioner is for regularization of his services, hence, this court is of the opinion that the matter ought to be allowed to be examined by the highest authority in the state, highest executive authority in the state. As such, on the request of Mr. So-and-so, this matter is directed to be listed immediately after reopening of the Bihu holidays.
My lord.
These matters as fixed items.
Highly obliged.
Obliged.
May it please your lordship. As per order dated 10/1/2025, the petitioner was supposed to file documents before the commandant, that was filed. And they were supposed.
Filed when?
My lord, in the month of February itself, my lord.
Can you give the date?
The exact date she could not tell, but in the month of February itself.
Yes.
So after that, lordship, on the 38/1/2000, February, no?
Huh?
February,
February itself.
Then lordship, because this letter is of 38/1/2025, so I think I have to take updated instruction because this is letter of January.
Mr. S. Sahul, and counsel for the petitioner submits that in terms of the orders passed by this court, his client had submitted the requisite documents before the concerned authority in the month of February 2025. Responding to the above, Mr. C.K.S. Borual and G. Assam prays for 2 weeks time to obtain updated instructions from the concerned authority. that is
Commandant, lordship.
Commandant of,
Commander 22nd Battalion. 22nd Battalion.
Commandant of the 22nd Battalion,
Assam
Assam
Police.
Battalion. 22nd Battalion of Assam Police. Prayer allowed, let the matter be listed immediately after the review vacation so as to enable Mr. CKS Borwa to obtain written instruction in the matter.
A date be fixed below?
Date will go to June. You want it June or after?
No. Okay.
May I please, your lordship? Lordship, matter relating to compassionate family pension, lordship. And petitioner father was a grade 4 employee in the office of the Joint Director of Health Service. And after the expire of his father and her mother, their mother would dole the leave in encashment benefit and other insurance fund and enter into a second marriage, lordship. And both the petitioner are minor, there is no person to look after them. So they are perished for the compassionate family pension of their father. And
Lordship, 2 weeks time may be granted, Lordship.
Lordship, 2 hours time.
Lordship.
They are minors looking for compassionate family pension. Why you want 2 weeks time in this matter?
Lordship, let it come in the.
Mr. Upamanu, the court has very little tolerance for this kind of matters.
Lordship, let it come after a week, Lordship.
After a
week, Lordship.
On Friday, you open it.
Yes.
Ali, lordship.
Mr. A. Ali, learned counsel is present for the petitioner on the request of Mr. D. Upamanu, learned standing counsel, Health Department, Assam. This matter is directed to be listed again on Friday, that is give the day, so as to enable him to obtain instruction and appraise this court as to the reason why the prayer of the petitioners for grant of family pension has not been considered today. Mr. Beach.
We are concerned, Lordship, the appointment of 2007, our name may be deleted. We are not dealing with the new pension scheme, Lordship. The director of pension will do it.
We'll do it on the next date.
Regarding family pension matter, my lord, that there is allegation of excess drawal in this case, my lord. So, Lord,
3 weeks time may be granted to file affidavit, my lord.
And Mr. C. Goswami, learned counsel for the petitioner on the request of Mr. PNRE Department, Assam. 3 weeks further time is granted for filing affidavit. Let the matter be listed.
And your bless.
My lord, in this case, my lord, respondent file, my lord, affidavit, my lord. My lord, 2 weeks time may be allowed for
Lordship,
reply.
fact is not that, Lordship. It's
One by one.
My lord, respondent file affidavit, my lord. I have time to take 2 weeks time.
Affidavit filed when?
My lord, I have received, my lord, on 13, my lord.
13th of?
13th of March, my lord. Before.
Lordship, it's not counter affidavit, it's a transfer matter, stay is there. So when I have placed the instruction, Lordship asked me to file it in the form, written form, the instruction. That is why it's a short affidavit only on the instruction. It's not a counter. It's a transfer, and for last 3 months, a stay order is in his favor, Lordship. That is, it's only to that much, this affidavit. That is there, pink flag is there.
So what you want to dispute? Which part of the statement in the
My
affidavit?
lord, they have stated that the medical board was examined by the petitioner, my lord. My lord, that, my lord, if my lord, the respondent authority, my lord, stated that he is a medically fit, my lord. I am nothing to say, my lord. My lord, kindly walk without walking stick, my lord, he cannot move, my lord, my petitioner, my lord. And he is ready to go from here, my lord. He is ready to go, my lord. My lord, he is a disciplined force, my lord. He know, my lord. My lord, only my lord, 2 weeks time may be allowed, my lord, for filing a reply, my lord, in this.
So your authorities are not going to look into his grievance?
No, that is not. First, he had completed his tenure, Lordship. Yes, Lordship. He had given 5 places of choice of posting. We have given 1 of his choice posting. Subsequently, because of medical ground, he given another 5 places of posting, which is in this state where he had almost 7 years. So now we have that. Earlier it was extreme hard. Now we transferred him to Bihar, which is hard area, but it's a plain area. Earlier it's Arunachal, Lordship. So now again, during this period, he had submitted a VRS also. That we have also sent that. Now see, he had again, after the stay order is allowed by this court, Lordship, he had withdrawn that VRS. And Now, again, last occasion, one medical document was submitted that he had to go for review medical examination. I have annexed at page 135. That is nothing, Lordship. It's a routine medical checkup, which he could done in any place, his new place of posting or anywhere. It is nothing. It's just only a, and it doesn't say anything also. There's 135 page. Some persons were medically examined. That is a routine in force, and he can do it in any place. And he is now he had joined Lordship.
Heard Mr. Alan Dehinga, learned counsel for the petitioner, also heard Ms. B. Sharma, learned CGC appearing for the respondents who has expressed urgency in the matter by submitting that due to operation of the stay order, the transfer of the petitioner is being withheld. Mr. Dehinga, on the other hand, prays for some time to file rejoinder affidavit. Be that as it may, having regard to the facts and circumstances of the case, as well as the urgency expressed in the matter, this writ petition is directed to be listed as a fixed item on 27th of March 2025 in the top of the list of admission column. The matter will be taken up for final disposal on the next date fixed. The writ petitioner may file rejoinder in the meantime, if so advised. Parties to come prepared accordingly. Interim order passed earlier to extended till the next day. We'll pass a final order on 27th.
May I please, Your Lordship? Your Lordship, by impugned suspension order, Your Lordship, 1/7/2024, Your Lordship, the petitioner was placed under suspension with effect from, Your Lordship, 26/2024, and show cause notice was issued on, Your Lordship, 28/2024, within the period of 90 days, Your Lordship. However, there has been no any review for modification or extension of the suspension order, Your Lordship. And till date, Your Lordship, the petitioner is.
It has been reviewed.
All right.
It has been reviewed. We'll like to file affidavit, my lord. This matter, my lord.
It has been reviewed when?
It is reviewed, my lord, on 29/10/24 and also in 27/1/25.
Let him file affidavit.
Yes, Your Lordship.
Mr. D.S. Dekal and counsel for the petitioner. The petitioner is aggrieved by the order of suspension dated 1/7/2024 issued by the Secretary to the Government of Assam Environment and Forest Department, placing the petitioner under suspension primarily on the ground that there was no review stroke extension of the suspension order within 90 days as per the requirement of law. Mr. Deka has, however, submitted that in the meantime, this departmental proceeding has been initiated against his client and the matter is progressing. Mr. D. Gogoi, Learned SC Forest Department, has submitted that the order of suspension issued to the petitioner was reviewed on 29/10/2024 and thereafter again on 27/1/2025. On both occasions, the order was extended. The Learned Departmental Council therefore prays for 3 weeks' time to file affidavit bringing those facts on record. Prayer allowed. This the matter again after 4 weeks. Let the affidavit be filed by the department in the meantime.
Much obliged, Your Lordship.
Your Lordship. Lordship made accordance to family pension, Your Lordship. Your Lordship, in favor of a unmarried and dependent lady who is autistic also, Your Lordship.
This matter we have to pray for some time because the instructions are awaited from the respondent also received from the office of the SP Lordship.
We'll give them some time. This is on 28th February only. This notice was issued. How much time you want?
3 weeks time, Lordship.
Heard Ms. G. Bora Learned counsel for the petitioner on the request of Mr. C.K.S. Bora Learned G. Assam appearing for the respondent numbers.
1 to 4.
1 to 4. 3 weeks further time is granted for obtaining instructions. Mr. S.K. Medi, Learned CGC is present for the respondent number 5. Let the matter be listed accordingly.
Transfer matter, my lord. I have got the instructions. I pray for a short accommodation, my lord. Lordship may post it before the Bihu vacation. We will file an affidavit by Wednesday next, my lord. Or by Monday, my lord, if possible. There are certain complaints against the petitioner, for which, my lord, he has been transferred. I have got the specific instruction in that regard. And their office notings, my lord, from to the level of the, my lord, chief minister to, my lord, transfer the petitioner from this particular institute to a separate medical college. Because of the complaints, my lord. I will bring it on
Is
record.
there any entry? He has joined already.
No, there is the interim order.
Interim
Lordship will
protection is
continue
there,
the
my lord.
interim.
That's why, my lord. By Wednesday, I will file it before Bihu vacation, my lord. If Lordship will give a date, we'll try to, my lord. If
Had
required, I will
Mr.
place
J.
the
Patwari,
record.
learned counsel for the petitioner. Also had Mr. B. Gogoi, learned standing counsel, Health Department, Assam, who submits that 1 week's time is required to file affidavit. Mr. Gogoi prays for posting this matter for further consideration before the upcoming Bihu vacation. Prayer allowed. On the request of Mr. Gogoi, this writ petition is directed to be listed again on 8/4/2025 as a fixed item.
Interim order is
Interim
taken.
order passed earlier to continue till
Only thing is that, my lord, by Wednesday, I will file my affidavit. They will file their reply before that. At least we will try to, my lord.
that. We will do it.
I am obliged.
For others, I think
May it please your lordship. My lord, the present manager of the respondent management has been sent. So to file impleadment petition, we need 3 weeks time. Lordship.
You want to file impleadment petition?
Yes, your lordship.
Mr. P. Kalita,
P.
learned counsel for the petitioner submits that during the pendency, but this is 2016,
Yes,
8
sir.
years. What is the order? What is the order?
Lordship. Just 10. Page number 10, your lordship. Outstanding dues regarding.
So why the dues have not been paid?
Lordship, as per my morning, that is the telecommunication, that outstanding dues till the age of 58 has already been paid. Total outstanding we have paid. But the question is arise because MD has been changed 2-3 times in the Assembly Corporation. But the dispute regarding, that is their doubt, we have to take instruction, whether that is he was in extension period or he is in a regular period. That is the confusion. It will be sorted out, Lordship, and in the next date, definitely I will take the instruction. We have paid till 58 years. He was extension for 2 years.
Huh? Up to 60 years.
58, because extension period is 58 years, 60 years. So we have to see details whether he's in extension period, and moreover, it has been informed me that he has worked beyond 60 years also. So entire thing in the next day, I will give the entire instruction.
No, that's correct, but in 2013, the court directs you to do it in 3 months. We are in 2025.
Lordship, I have to take instruction, Lordship. So many officials have been changed, Lordship. After 4 weeks, matter may be fixed, Lordship.
Mr. P. Kalita, learned counsel for the petitioner is present. Mr. T. Das, learned counsel appearing for the.
Assembly Corporation.
No, you are.
Contemptor, for alleged contemptor.
For the alleged contemptor prays for 2 weeks further time as last chance to obtain instruction and appraise this court as to the steps taken by the authority in ATC to comply with the court's order. Although there has been enormous delay in compliance with the court order, yet after considering the submissions made by Mr. Das, 2 weeks further time as last chance is granted to the respondent to comply with the court order. Let the matter be listed accordingly.
Obliged.
Obliged.
Perhaps service report is awaited on the newly implemented respondents. Otherwise, the contempt is of 2016, my lord. They had approached the Honorable Division Bench also. They went up to the Supreme Court. Everything was dismissed.
One more chance and then we'll see what can be done.
Madam?
Because this is notice was sent on November. Notice was issued to respond number 5 in November.
November, madam.
AD card has not been received.
Madam.
Or else you have to take fresh steps.
I'll take first steps, madam.
All right. Mr. R. Majumdar, learned counsel for the petitioner, submits that since service report on newly implemented respond number 5 is still not available, the petitioner be granted leave to take fresh steps for service of notice upon the same respondent. Prayer is allowed. Notice be issued to the respond number 5 afresh by registered post with AD, making the same returnable in 4 weeks. Petitioner to take steps within a week from today. Let the matter be listed accordingly.
Obliged.
I need some more time to file substitution petition for respond number 2, Your Worship.
On the request of Mr. L. Mohan, learned counsel for the petitioner, 3 weeks further time is granted to file impleadment application. List accordingly.
Lordship, kindly peruse the order at 19 to 24, Lordship.
None appears for the petitioner. The petitioner's counsel has remained absent on 3 consecutive occasions in the past. Mr.
S.R. Borua.
S.R. Borua, learned counsel is present on behalf of the sole
Contempt.
What do you want to show?
Lordship, that last order 19 to 2024, my instruction has been that recorded and kept on record also. In fact, the petitioner has not cooperated to comply with the orders. He was supposed to provide some vital documents for his pensionary benefit.
Means that due to non-cooperation of the petitioner, the order of this court could not be complied with. Full stop. The said submission of the petitioner has been recorded in the order dated 19 to 2024 passed by this court. However, the petitioner's counsel has not come forward to deny and dispute the same. If that be so, there cannot be any question of willful disobedience of the court's order. Situated thus, this contempt case stands closed by granting liberty to the petitioner to avail appropriate legal remedy as may be permissible under the law, if so advised.
Obliged.
Lordship, some time may be granted to implead the new incumbent, Your Lordship. And for impleadment.
On the request of Mr. J. Ahmed, learned counsel for the petitioner, 3 weeks' time is granted to him to file appropriate application for impleadment of new incumbent in the office of the authority responsible for implementation of the court's order. Mr. S. Bora, learned counsel, is present for the
Respond number 1, madam.
respond number 1. List accordingly.
Much.
May please all lordship, in respondent number new incumbent has joined in place of respondent number 2, my lord. He may be made a party in this case, my lord.
The last order says what steps were taken by the then respondents to implement the order of this honorable
We have
court.
already sent that for to
I'll
vacate,
impede, my
send for
lord,
file.
but the other respondents, they must have done something for implementation of the order. I'll implement the new ones, no difficulty, madam. But the other respondents, they
You are
slept over
appealing for
the.
whom?
I'm for respondent number 2, my.
The review filed by them was dismissed on 10/5/2024. Till date.
My lord,
nothing.
we have already sent for vetting, my lord. That is, I could not file today because of my lord changes of that incumbent, my lord. So let the implemented party as a respondent number.
That is another thing.
That is another.
Even if it doesn't implead, you have to file the affidavit here.
For those persons.
He is in service, respond number 2.
Respond to his service, my lord.
He will have his accountability.
Then we have to.
Mr. R.
send 25
Majumdar, learned counsel, is present on behalf of the petitioner. His A. Gahan, learned counsel, submits that affidavit on behalf of the respond number 2 is ready but could not be filed due to change of the incumbent in the office of DG Assam Rifles. Full stop. Mr. Majumdar has responded by submitting that he would move application for impleadment of the new incumbent. However, Ms. Gayan is granted 2 weeks' time from today to
Yes,
file the affidavit on behalf of the respond number 2.
Yes, ma'am. Must come, yes.
Obliged.
Mention.
No, I have instructions. I'd like to file affidavit, my lords.
On-
There are two issues, my lords. The petitioner was bestowed with certain promotional benefits and also some financial benefits. The dispute is regarding the date of birth. So now the AG is raising objections, and we have called for the Soil Conservation Department, which was the original employer of the petitioner, my lords. They have called for the service book. Once it comes, my lord, we'll process everything, my lords. That's under consideration.
AG is raising objection means AG is.
Not AG, madam, there's a different recruitment department, there's a PAG, madam, PAG bracket ANE. Because two dates have come. 2 dates have come here because there was a graduation list based on which the benefits are given to him. Now, if we process on the date agreed to by the petitioner, my lords, that benefits will have to be taken away from him. That has to be recovered to him, the financial benefits and the promotional benefits, my lords. So we are in the
You want to
process of.
file affidavit in which case?
In contempt, we have already filed, madam. In a writ petition, we like to file affidavit, my lords. We have received our instruction, madam. My lord.
How much time you want?
2 weeks, my lord.
May I submit? But all these grounds have become stale. Well, there was a dispute in regard to my date of birth and my date of superannuation. Ultimately, your lordship's order is at page 42. A consensus was they had come that my date of birth is as per my date of birth, my superannuation will be 31/3/2023. Accordingly, I accepted it, and this honorable court directed that after furnishing the copy of this order and all my retired benefits has to be paid. That expired on 31/10/2023. Now, the concerned officer of the Forest Department tried to overreach the order of this honorable court and tried to deduct. They're saying that I have work access from 1st of April 2022 to 2023. Then we came before this honorable court, and there is a stay order operating against that order also, because prima facie that is because all these issues have been taken up in the earlier writ petition, and ultimately that consent order was passed and that undertaking was given by them. So today in 25, if they come and say they again want to turn back the clock, my lord, that your lordship will take it, because it is ultimately the court and the contemptor. I can only point out the facts to your lordships, my lord. Your lordship's order is at page 42, and they should have paid to us by 30th of October 2023, all the dues. Now, a person has been superannuated on one pretext or another, they are delaying the matter.
So it is payment of.
Pensionary benefits and other retired benefits.
All right, take down. I heard Mr. B.D. Cole and his senior counsel for the petitioner, who submits that despite the specific order passed by this court, neither the pension of the petitioner has been released till today, nor has the order of this court been complied with in any manner. Mr. D. Gogoi, learned counsel for the respondents, on the other hand, has prayed for some time to file affidavit on the ground that he has received updated instruction. Be that as it may, considering the nature of issue involved in this proceeding, the matter calls for expeditious disposal. As such, this contempt case be listed again on 3/4/2025 along with the connected writ petition for necessary orders. We'll pass final order on.
Because of the last
In fact, we asked him to submit the papers. What he says,
we have
lost it. We have lost it. He lodges an FIR. Yes,
Either we'll close the contempt or we'll draw contempt proceeding against the
And
official.
on 3rd of March, your lordship has categorically observed in your lordship's order that this is the last time you are seeking instruction.
No, I have covered instructions.
Right.
Always.
On that day, on
Yes.
on 3rd April, we'll pass orders.
Yes.
Well, I like to, my lordship will kindly observe to bring his service records, all records, records in original.
You bring it.
I'll bring it, my lord. And my lord, the Department of Soil.
Say that nobody will stop Mr. Gogoi from bringing the records.
My lord,
Stop the order.
my lord, we like to implement the Soil Conservation Department also.
You can't implead, you are
He has to
responding.
implement. Somebody has to implement because the original service book lies there, my lord.
These are secondary issues. There is an order from the court. That order has not been modified. There is no prayer to modify. So that has to be implemented. Nobody can come in the way.
I got
That
my
is-
point, my
that
lord.
is the constitutional scheme.
I got
It's
it.
an interdepartmental.
I got it, my lord.
My lord,
I got the cue, my
quite
lord.
surprised.
I got the cue.
My lord, may I pray for the matter to be taken up after 4 weeks, because my lord, in the meantime, the contemners have filed an appeal and the appeal is pending. There is an interim order.
There is an interim order.
So my submission before lordship is to wait for some.
No, not 4 weeks, awaiting the outcome of
Yes,
appeal
ma'am.
filed where? Heard Mr. S. Chakraborty, learned counsel for the petition.
Appeal has been filed and an interim order was passed on 25/11/24.
Also heard Miss, your name please?
Yes, Sharma, your lordship.
S. Sharma, learned counsel appearing for the respondent number?
All the respondents.
For the respondents who submits that there is an appeal preferred by the state against the order of the learned single judge wherein an interim order is operating. Appeal by the state or the bank?
It's a bank,
By
By the bank. Wherein an interim order is operating. Ms. Sharma has produced a copy of the order dated
25/11/24.
25/11/2024, passed by the division bench in writ appeal number 303 of 2024. I perused
My
this
lord, this particular contempt, the appeal is 60.
60 of 24. But all are your lordship.
All are, but
written,
this
connected.
petition.
writ appeal number 60 of
60 of
2024.
2024.
Awaiting the outcome of writ appeal number 6660 of 2024, this matter stands adjourned sine die.
Mal.
May I please, your lordship?
Yes.
Lordship, IPF, the respondent number 1, the Director of Health Services. We are appealing for the first time. We may be allowed some time to come back with the instruction, lordship. This, with regard to payment of area salaries.
All right. Your name, please?
Yes, Sharma, my lord.
Heard Mr. S. Sharma, learned counsel for the petitioner.
D.
Mis-
Deca.
Mr. D. Decker, learned counsel, has
Respondent one.
entered appearance on behalf of respondent number
1, lordship.
1 and 6, 2 weeks time to file affidavit.
Lordship.
Mr. H. Cholier, learned counsel, is present for the respondent number 2 and makes a similar request. In view of the above.
Worship, this regards to payment of area salary that has to be done by respondent number 1.
No, all right, you are appearing. In view of the requests made by the learned counsel for the respondents, this matter stands adjourned for 3 weeks.
Lordship.
In the meantime, affidavit be filed, list accordingly.
Highly obliged, lordship.
61.
No, the notice was issued by the honorable court. The service is complete. My friend appears.
So you come this side.
No, this is against the Union of India.
Oh. All right.
Lordship, I have appeared.
Service is complete, my lord.
I have filed Okalana Lordship yesterday
You
on
appeared for whom?
on behalf of respondent number 6.
I'm 1 to 5 lordship. Lordship, we have time. We will find the affidavit.
Mr. D. Nath, learned counsel, has appeared for the writ petitioner. Whose name? Mr. B. Chakraborty, learned counsel for the respond numbers 1 to 5, and Mr.
UB Sharma
UB
Lordship.
Sharma, learned counsel for the respond number 6, have both prayed for 3 weeks time
Kindly 4 weeks, Lordship.
4 weeks time to file counter affidavit. Prayer is allowed. Let the matter be listed accordingly.
There is an interim order.
Interim order passed earlier to continue.
Lordship.
Highly obliged, Lordship.
My lord, we have 2 IAs, my lord. My lord, there is some confusion, my lord, with regard to the cost title. What happened, my lord, here we wanted to implead 2 respondents as respondent number 14 and 15 in the main writ petition, my lord. And as such, we have preferred these 2 IA. One IA is for impediment to the writ petition, and another IA is impediment of these 2 respondents in the IA, which we have filed. Now, my lord, on earlier occasion, Lordship has raised an issue. Yes, my lord, that case, my lord. Now, my lord, my humble submission before your lordship is that when we file an IA, my lord, kindly come to the cost title. How we prepare it, my lord. Lordship is taking up which IA, my lord? IA number?
743.
743. Okay, my lord. So I am taking up 743, my lord. Now, my lord, what we write, my lord, in the matter of we file what is this interlocutory application for. Then we write, and in the matter of petitioner's name, we write this is the petitioner, means he is a petitioner in the main case, the writ petition, or the IA. Then, my lord, we write versus, we mention the parties which were there, 13 parties we have mentioned, they are the respondents in the main case.
And then again, we bring up, my lord, and in the matter of, now he is an applicant, my lord. Kaushik thus comes as an applicant here. Versus we write, my lord, we have mentioned all the 13 respondents who were there in the main case. Along with that, my lord, we have also made 14 and 15 a party because we want to impede them. Now, my lord, Lordship had raised an issue, my lord, on the last occasion that why we need up to 13. This 1 to 13 need not be made a party. Since we want to impede only 14 and 15, so 14 and 15 has to be a party here. Now, my lord, this specific IA, my lord, which we have filed, this 743 is for impediment of 14 and 15. Now, my lord, here we have made 1 to 13 also a opposite party here, my lord. My lord, we have been doing here, my lord, this is a usual course of practice which we have been doing. And my lord, the reason behind that is that, my lord, now when we want to impede 14 and 15, 1 to 13 might have a say. And my lord, 1 to 13 are the main litigants. In the writ petition, they are the main litigants, my lord. They are contesting against us. Now, my lord, if we come up with an IA, whatever IA, my lord, be it for impediment or be it for something else, if we don't make them a party, then, my lord, it will be playing behind their back, my lord. Now we want to impede 14 and 15. Now, my lord, they may come and say that this is our delay tactic or something, whatever it is, my lord. Any sorts of objection may come. So, my lord, only to give them an opportunity to have their say, my lord, in this IA, we have made them a party. So 1 to 13 is there and 14 and 15, because 14 and 15 will come up before this court and they may say that we are not a necessary party. Although the applicant is saying that we are a necessary party, we need to be impeded, but we are not a necessary, they will have their say. And, my lord, equally, my lord, since they are the main party in the writ petition, we cannot come up with any IA or any petition, my lord, behind their back. They necessarily has to be a party. Now, my lord, Lordship has mentioned about that, my lord, system, my lord, that having some problem, my lord, with the system, my lord, new systems are coming up, my lord, we understand. But, my lord, system has to go according to us, my lord. We will not go according to the system. Software has to change, my lord. Because, my lord, we cannot stop them to object, my lord. They have every right to object this IA of mine, my lord, which I have filed, my lord. So that is my submission.
Paying on behalf of respondent, one personal dependent, we have already filed our affidavit. We have no objection. If they want to impede PNID, I think, PNID is part. We have no objection.
No, you take your seat. That's not, the question is not whether you have objection or not. Question is on a.
Saying the government might have any objection.
For this case, my
Mr.
lord.
Khan, your submissions look very attractive, but it cannot be accepted without a report from the registry. The reason is as follows.
My lord.
You want an order to be passed by impleading two opposite parties. Correct?
Yes, my lord.
So insofar as your prayer in the IA is concerned, this is against the opposite parties. The opposite parties you want to implead.
14
right?
and 15, yes.
No IA is ever listed without the connected writ petition. So whenever the writ petition is listed, the other respondents are always present before the court. So if they want to raise an objection, they can always very well do it. But a respondent cannot oppose the impleadment of another respondent, another person as respondent, if the court feels that this impleadment is necessary on the ground stated in the IA. This is reason number one why your argument cannot be accepted. Secondly, I have seen petitions where the applicants already implead them as respondent number so-and-so. They are shown as respondent number so-and-so. Say you want to implead two opposite parties as respondent numbers 14 and 15. It may or may not be the case in your case, but there are other applicants coming in. They are shown as respondent numbers 14 and 15. So that means whether the court passes an order, according to you, they have already been impleaded. So tomorrow, for some reason, if the court does not allow, then what happens to respondent number 14 and 15? 14 and 15 is already in the system. There is no guarantee that the court will allow it. Normally the court does. Supposing the court dismisses your writ petition.
My lord.
By that time, respondent 14 and 15 are already in the record. You have already impleaded them. The court has rejected your prayer for impleadment. Tell me what is the mechanism to delete their name as respondent number 14 and 15 as per your understanding. You must first argue on that.
My lord. My lord, what happens, my lord? Suppose we file a writ petition, my lord, with 13 respondents, my lord. That writ petition is filed, my lord. It is on record. Now we cannot my lord, add any party, any respondent to that writ petition, my lord. Suppose my main writ petition, I can, if there are 13 respondents, it is 13. 14 and 15, I cannot add, my lord. In the, I cannot go back to the writ petition and add it, my lord, either by hand or anyway, my lord, without the order of the court. Now, my lord, for that order of the court, we are filing this IA. And what is our prayer in the IA? That the opposite parties, number 14 and 15, may be added as respondent number 14 and 15 in the main case. So, my lord, in doing so, my lord, we are not bringing in them, my lord. We have not stated, they are not mentioned as
It
respondent.
may not be in your case. In some applications, they are implemented as 14 and 15.
My lord, that means they have added, my lord, if I can, I go back to
It was
the.
called for a report from the registry on that.
Yes, my lord.
And then we'll go ahead with it. If the registry says it is fine, then we'll go ahead with it.
My
The
lord,
registry may say that.
My lord.
But see, the court doesn't have a fixed view on this matter.
My lord,
Whatever is
I
correct,
understand, my
we'll
lord.
do it.
I understand. And my lord,
So we'll
as
call for a
regards-
report from the registry.
Yes, my lord, yes.
1 week, next week we'll take it up.
Next week, my lord, I will not be there, my lord. Any day next month, my lord.
Any day next month.
First week of next
All right.
month, my lord.
All right. Let it come. You take down applicant IA number 743 of 2025. By heard Mr. M. Khan, learned counsel.
Khan,
for-
madam.
Yes, learned counsel for the applicant. By filing this IA, the applicant is seeking impleadment of 2 other persons as respondent numbers 14 and 15. 2 other authorities, 2 other officials as respondent numbers 14 and 15 in the connected writ petition. Full stop. However, those 2 authorities have already been impleaded as respondent numbers 14 and 15 in the present IA. Full stop. Since the present system in the High Court is heavily loaded, heavily mounted on the CIS system, wherein electronic database has a key role to play. A confusion arose as to whether the opposite parties numbers 14 and 15 should be impleaded as the only opposite parties in the IA, insofar as the IA is concerned. And only after the court allows the prayer of impleadment can they be impleaded as respondent numbers 14 and 15, or whether these 2 opposite parties can be shown as opposite party numbers 14 and 15, even in the IA, before the court allows the prayer for impleadment. Full stop. In order to have clarity in the matter and to avoid further complications insofar as the CIS system is concerned, this court is of the view that a report from the registry ought to be called for, clarifying the issue. As such, the registered judicial to examine the matter and submit a report. Let this writ petition be listed again in the 2nd week of April.
First week, my lord.
First week of April 2025 as a fixed item. Mr. CKS Borua, Learned G. Assam, Ms. MD Bora, Learned Standing Counsel for the Cooperation Department, Ms. D. Jain, Learned Counsel for the Social Justice Department, and Mr. D. Upamennu, Learned Counsel for the Health Department, Assam is present.
My lord.
Let it be clarified.
Yes, yes,
and
my lord.
move
Yes.
accordingly. Yes.
Yes, my lord. Moreover, my lord, one thing comes in my mind, my lord. When we file this IA, already, my lord, they have registered the IA and 15 names are shown in the CIS, my lord. So there should not be any problem, I think, with regard to the IA.
That's the problem. If this IA is dismissed, then these 15 names they cannot remove any name from CIS.
With regard to the IA for impediment.
They cannot remove any name. CIS data is one-way traffic. Once you push it, you cannot bring it out.
For implement of
If they show today that a case is disposed of, even if the judge changes his mind, the case is disposed of.
But their name is not shown in the main writ petition.
Maybe, but it is coming in the CIS data as one of the complete array of parties, na?
Yes, yes.
He's
yes.
coming in as 13, 14 and 15.
With regard to the history of the case,
Correct.
somewhere their name is there, my lord.
Correct.
Yes.
So let them examine.
Yes, I understand, my lord. Grateful, my lord. Okay.
Hmm. What are these three expeditions? Three. What are these three expeditions?
Only one petition.
Acha, then in some earlier order, 2193, 4486 and 4606. What are these expeditions? 4486 of 2023 and 4606 of 2023.
Those are disposed of.
Those are already disposed of.
They have been disposed of.
What are those expeditions?
Those were for seniority. Seniority issues.
No, my lord, there are 6, 7 read petition. 3 has been disposed of. That was with regard to other disciplinary proceeding against Ankit Kumar and other 2 persons. And that is the seniority list. It has not been disposed of. It is pending, still pending, seniority.
Which is still pending?
Seniority list, my lord. Cases belonging to seniority list.
No, just
pertaining to
let me
seniority.
understand.
Yes, ma'am.
Please take your seat. I'll hear you. What is the issue in this WPC 2193 of 2023?
2193 is the present case, my lord. Disciplinary proceeding matter, my lord.
Some penalty has been imposed.
Some penalty has been, minor penalty has been imposed.
Okay. So according to him, this order is not legal.
According to him, because on the ground that IO has exonerated him, but the disciplinary authority has deferred with the IO's report and given him an opportunity to file your reply against the observation of the DA. He has filed his reply, and after hearing him, the matter was penalty has been imposed. So that penalty has been challenged by this.
What is the charge against the petitioner?
Charge, my lord. There were 4 charges of articles. Article 1 and 4, as per the disciplinary authority, it has been proved. One is that there was a missing of 385 bags, my lord, and Article 4 is not maintaining the food FSD, that is food storage depot. Stacking was not properly, so that was the charge. 2 charges. 2 charges, according to the disciplinary authority, it has been proved against him. And other 2 charges, he has been exonerated.
Now, what is the ground on which the writ petition has been filed?
Ground that he has filed when he has given the charge to his subsequent officer, that is Ranjit Kumar Boro, and he has not put any objection that the stacking were not properly made.
No. What is the ground on which petitioner has been challenging the order?
Yes, that is the ground. Basically, that is the ground because the officer taking over the charge of the FSD, that storage depot, has not put any objection. So, according to him, he should be, he is not liable.
That is the ground.
I am in the Your Honor, regarding this, if I give a background that when he was
you can give everything, but you have to first answer the query of the court. When the court asks a question,
yes,
you give a straight answer to that. Then you go into your background, everything. What is the ground on which?
The ground on which we are writing this objection, while this agreement memo was served on me, and when I replied, I had taken care of all the things. So this order for continuing of the earlier order of the regional authority, continuing that stoppage of 2 increments is not as per the legally valid, because
Mr. Gupta, I must tell you this. The parameters on which the court can interfere in these matters are very well laid down. If you do not have clarity on that, your arguments, then it will be difficult for you, because I have delivered many judgments, and the ground you are urging, I will not even consider it. This is not a ground. Are you aware of the grounds on which these kind of orders can be interfered with? If you're not aware, then you will not know what has happened to your case. I will dictate the judgment, and then there will be trouble. These orders of penalty can be assailed in a writ petition on 2 or 3 defined grounds. The ground you are saying is not one of the grounds. So that means before even you argue the matter, the writ petition will be dismissed. Because that's not a ground. The court can interfere in these matters only on the grounds which are legally recognizable. Are you aware of those grounds?
We are disputing the very punishment given.
That cannot be a ground in a writ petition.
Because the additional facts have come to the light also.
Okay, you argue, but I have pointed it out. So now it is entirely your responsibility what you want to do.
Sir, presently I'm a manager in Food Corporation of India in Arunachal Pradesh, posted in Arunachal Pradesh. But this case relates to my tenure in Bhalukpong when I joined in 2011. There I got the promotion from AG3, category 3 post, from AG3 to AG2 and continued the same at the FSD there in Bhalukpong. It is one thing that Ranjit Kumar Bora, AG1, was posted at the Way Bridge in charge at that time. And I was posted there. I handed over charge of first I was given the charge of at the time depot manager and this storage depot. Both were combined posted. So I was depot manager at the time. At the same time, I was having the charge of the the only said, which has got 2 compartments, A, B, and C. Now, I handed over charge to Mr. Arup Kumar Sekia, who was another officer of AG2, who it is in page number 141, Your Lordship. What 141 on the charge of the said in charge of FSD Bhalukpong on 31/7/15 opening balance. It was given to Arup Kumar Sekia. Now, after I handed over charge to Arup Kumar Sekia, I was posted as the depot in charge. Now,
So there is a review petition pending.
Review petition, my lord, that is also disputed. He has to file review petition before at the Delhi office before the CMD, my lord. He has filed this this review petition before the divisional office Nagaon, my lord. So we have in the affidavit of we have categorically stated that the CMD has not received any review petition.
Your Lordship, I'll show the proof that a review petition was.
So then why don't you submit another review petition before the CMD? We'll ask him to consider your case and dispose it off within 8 weeks. Because already listen. Your penalty has already been implemented.
Yes.
Implemented.
Now, if your review is accepted, then they will revert it. That's the only thing. Since you say that you have submitted a review and they are saying that they have not received copy, we'll make way for you to submit a fresh review before the CMD and direct him to consider it in accordance with law and dispose it off within a period of 3 months. After that, if you are still aggrieved, you can always approach the court. Otherwise, these are all factual disputes you are raising. The only answer the court will say is that these are not matters for the writ court to interfere. It will cause prejudice to your client.
Your Lordship,
This has been submitted before the DO.
No, it is not. It is submitted to proper channel.
But it has been submitted to the DO.
Your Lordship, you kindly see this. See this.
All right. If that dispute you go into, then it will be further delayed. If the dispute,
in the similar petition which we got a decree in our favor, I mean, order in favor that relates to the earlier petitions. In that same case, they say that it is not sent.
No, that was,
Because
it was there, my lord. It was filed before the CMD, my lord. In the other matter.
In
was-
the
is
other
there.
matters, it was filed before the CMD and it was accepted.
No, it was pending, but by the meantime, the honorable court has decided the matter. That was pending since long. That was pending since long time. That was the consideration. But herein, he has filed the review petition before the Nagaon office, my lord. Not even in the regional office.
Because all the communications have to be sent through.
Not
proper
proper channel. It's a review
channel.
petition.
I was
You have to
posted in
directly.
Nagaon. I was posted in Nagaon. I sent the application addressed to the managing director.
Here review.
My lord, CMD, my lord.
Where is your review petition? Where is it? No,
Page
no,
number
you-
132.
is it in the record?
Yes.
Which
Your
page?
Lord, your Lord, 132.
District office, Nagaon.
Why don't you give a fresh copy of this, this review petition? And we'll ask the CMD to consider it and pass appropriate orders if you are agreeable to it.
I did.
Otherwise, we can
I'm
hear.
agreeable, your Lord.
Because these are all factual disputes. Read court cannot go into factual dispute. This is the law.
Yes.
But once the review petition is either rejected on wrong grounds, then the read court can examine your matter.
Yes.
Agreeable?
Yes, my lord. Yes, my lord.
I'm agreeable to it. Your Lordship, meanwhile, this case will remain in,
No, we'll dispose it off.
Your
Lord, we
Lordship,
have stated in our paragraph 14, my
this
lord.
will be required to be filed again, all these annexes and all these things will be taken. Because in a earlier, once it so happened, the case was disposed of, and they took the way they had
See,
mentioned.
Mr. Gupta, if you agree, then this order will be passed. If you disagree, then also this order will be passed.
My lord, may kindly see page 190 of my affidavit.
It's
in
all
office.
got to do with perception and understanding of lawyers about the legal issues. You are raising factual disputes that this is not correct, this he was not there, the manager did not object. So therefore the order is wrong. These things cannot be looked into by the High Court. So you have to raise these matters before an authority under the statute, and depending on how they deal with it, the High Court will react. So if you agree, it will be one-page order. If you don't agree, it will be two-page order. The managing director will have to discuss. This is the way law operates.
I'm agreeable with you.
Because your grievance, we understand, but we cannot scuttle the principles on which the High Court is to function. Otherwise, what happens is orders are never implemented. We have to follow the process. Whether you have to file another writ petition, that could be, you retain these papers. He will give you the cost of Xerox, Mr. Singh, he is a kind man. Huh? His problem is he doesn't want to spend money for Xerox. Is that the problem?
It's not that.
Then what else is the problem?
It's not like, I mean, the full exercise afresh. That
My
is
lord,
what I know.
my affidavit in opposition, page 190. It's an letter from the CMD office that they are stating that we have not received any review petition, my lord.
Page 190.
190, annexure B. In this regard, it is once again informed that this office has not received any review petition dated 15/3/2022 filed by Sri Ankit Kumar till date as per the available record. Thus, no action is
And
pending.
the
at this
review is permissible under which provision?
My lord, I'm coming.
Is this the last matter?
74, my lord. Section 74 of the Food Corporation of India, my lord, I'm submitting. Under Food Corporation of India, within bracket staff regulation 1971.
Can you just possible? All right, take down. Heard Mr. A.K. Gupta, learned counsel appearing for the writ petitioner. Also heard Mr. V.K. Singh, learned standing counsel FCI, appearing for all the respondents. Full stop. The writ petitioner herein is presently posted as a manager in the Food Corporation, in the FCI go down.
Food Corporation, yeah. The food storage depot, Bhalukpong.
At the food
Storage
depot at
Bhalukpong.
Bhalukpong. Full stop. On On 23/11/2016, a departmental proceeding was initiated against the petitioner via charge memo number FCI /RO /ITA VIG shortage BHPN 2016 3492. You'll get in the synopsis. Whereby as many as 4 articles of charges were brought against the petitioner. Full stop. The writ petitioner had submitted his written statement of defense denying all the charges. Full stop. However, not being satisfied with his reply.
No, my lord. Inquiry report has exonerated Ankit Kumar, and other officer Ranjit Kumar Boro was imposed. It was held that it has been proved. Thereafter, disagreement memorandum was issued by the disciplinary authority. My lord, if my lord will come to index, my lord.
So not being satisfied, inquiry was conducted.
Yeah, oh, sorry,
Why
sorry.
am I interfering? Not being satisfied with his reply. An inquiry was conducted into the charges brought against the petitioner and another FCI employee, namely
Ranjit Kumar Boro.
Ranjit Kumar Bora. Full stop. At the conclusion of the inquiry, the writ petitioner herein was exonerated in respect of the charges numbers Roman 1, Roman 2, Roman 3, and Roman 4, all capital, brought against him. Full stop. However, the disciplinary authority had disagreed with the findings of the inquiry officer in the report dated. What is the inquiry report date?
28/11/2017.
28/11/2017. And after granting an opportunity to the writ petitioner to show cause as to why a different view should not be adopted.
The inquiry report dated is 15/5/2017. 15/5.
15/5/2007. Please don't make these mistakes. Huh? This is the minimum we expect from you. 15/5/2017. After granting the petitioner an opportunity to show cause as to why the disciplinary authority should not differ with the opinion of the inquiry officer, the charges under Articles 1 and 2,
1 and 4.
1 and 4 were held to be proved against the petitioner. Consequently, the penalty of in here you will get it in synopsis. Reduction of 2 stage of, where is the improved order?
Page 87, it starts, my lord. Relevant page is 93.
2818.
Penalty order.
2818, page number 87.
Page number
87.
Relevant part is 93.
I'm asking where is the relevant penalty? Penalty, page 93. Page 93, you'll get it. Reduction of 2 stages, so and so, was imposed upon the petitioner. Full stop. Aggrieved by the order of penal, wide order dated, wide order dated 2/8/2018, the penalty of so-and-so was imposed upon the petitioner. Aggrieved by the order of penalty dated 2/8/2018, the petitioner had preferred an appeal before the executive director, FCI, any zone, which was rejected by the order dated
3/12/21, my lord.
3,
12/21.
is it correct?
Yes, my
3/12/2021, Mr.
Yes, my
Gupta? Is it correct?
Yes,
3/12/2021. According to the writ petitioner, he had preferred a review petition submitted through proper channel before the Managing Director FCI on 15/3/2022, seeking exoneration from the charges brought against him. Notwithstanding the same, no action has been taken on his review petition. Situated thus, the writ petitioner was compelled to approach this court by filing the present writ petition. Full stop. Opening his arguments, Mr. Gupta has submitted that the inquiry officer had correctly appreciated the evidence available on record to arrive at a finding that none of the charges had been proved against the petitioner. However, reversing such finding with regard to Articles 1 and 40 and 4, the disciplinary authority has arrived at an erroneous finding of fact by ignoring relevant materials, including the statement of the godown manager that he did not object to. What was your?
Taking over.
At the time
Taking
of
over the charge.
handing over, taking over, he did not object to any shortage and all these things.
Including the fact that at the time of handing over, taking over
over the
charge
charge.
of the godown, the previous manager did not raise any objection pertaining to shortage of any storage. Full stop. From the tenor of argument of Mr. Gupta, it is apparent that the petitioner is assailing the order of the disciplinary authority primarily on the ground that the same has been issued after taking note of same has been issued on erroneous consideration of material facts and particulars of the case. Full stop. If that be so, it is obvious that the departmental authority at the highest level would be best suited to take a call on such plea of the petitioner. Full stop. It is only after the departmental authority takes a view in the matter, the writ court will be in a position to appreciate the submission of the petitioner's counsel. Full stop. It has been brought to the notice of this court that as per section 74 of the Food Corporation of India (staff) regulations, 1971, a review in a matter of this nature would lie before the managing director, chairman cum managing director of FCI. Full stop. Although the petitioner has asserted that he had submitted a review petition on 15/3/2022, yet the respondents have brought cogent materials on record through counter affidavit to submit that no such appeal, no such review petition was received by the office of the CMD FCI. Full stop. Mr. Singh, Learned Standing Counsel FCI, has fairly submitted that if the petitioner is keen on preferring a review petition, the same can be considered even at this stage. If a copy of the review petition dated, what is the earlier?
15/3/2022.
15/3/2022 is presented before the office of the CMD FCI. Full stop. If that be so, this court sees no valid reason as to why the matter should not be remanded to the CMD FCI to take a decision on the factual issues raised by the petitioner assailing the order of penalty. Full stop. The Learned Standing Counsel for the FCI has also agreed to such a recourse. The petitioner's counsel, Mr. Gupta, has submitted that if the matter is remanded to the CMD, the this court may issue a direction to dispose of the review in a time-bound manner. By taking note of the submission made by learned counsel for both the sides, this writ petition is being disposed of by providing that within 2 weeks from today, the writ petitioner would submit a copy of his review petition filed on
Filed on 15/3/22.
15/3/2022 in the office of the CMD FCI at New Delhi. 2 weeks or 3 weeks?
3 weeks.
3 weeks. Full stop. After 3 weeks, by obtaining proper receipt in respect thereof, submit a review petition along with a certified copy of this order before the CMD FCI at New Delhi by obtaining proper receipt. If such review petition is submitted by the petitioner, the same be considered on merit and disposed of
90 days, within 90 days.
by a reasoned order within, preferably as expeditiously as possible, preferably within 90 days from the date of receipt of copy of the review petition. Full stop. If the petitioner continues to remain aggrieved in the matter even thereafter, it will be open for him to approach this court by filing fresh writ petition. Writ petition stands disposed of accordingly.
Your lordship, will you be directly sent by post to?
You can send it whichever manner. When you send it within 3 weeks, it will be sent to the office.
Or through.
No, you directly send
Directly.
it,
By
not through
registered
me.
post with AD. Then obtaining receipt no like. IAS is the highest and disposal. All right,
Obliged.
that will be good for your client. Get an answer. There will not be much for you to argue now. Yes.